Yes, do I not look like I'm doing well? I mean, I'm tired.
I can only imagine. All right, anything we need to address before we bring the jury back in?
No, Your Honor.
Nothing from the defense, Judge.
Have Mr. Ross come on up. Mr. Ross, just remember that you're still under oath, okay?
Yes, ma'am.
All right, let's go ahead and bring our folks in.
Thank you, Judge. Good morning, Mr. Ross.
Good morning.
Welcome back. Yesterday, you had some time to sit on the witness stand and provide testimony. Do you remember that?
Yes.
And we ended off talking about when you got to Delaware, and you said that your sister had found out what happened. What did you mean by that?
I was indicating that she had found out that me and my mom had gotten into that verbal altercation. I got removed from her residence and couldn't stay with her anymore.
Okay. Now, yesterday, we were talking about some of the conversations and interactions you had. One thing you had mentioned is that you had had a falling out with Thomas Blackwell. You remember that?
I do.
In addition to that, you also had a falling out with Mr. Sykes.
I did, yes.
And what was the issue about? What occurred?
Sykes, he's gross, honestly, in my opinion. The same day that I had fell out with Christian Sykes was the same day I also fell out with his cousin, and we were at his cousin's house. We were smoking marijuana, and I had seen Sykes giving his cousin oral pleasure, and it grossed me out. And so I called my mom, asked her to come get me. I left. I went to the top of the street. She came and got me, and I didn't contact either him or Thomas Blackwell since that day.
You mentioned that on the Sunday after this incident on Buckhorn that Mr. Sykes had called you to apologize. What was that in reference to?
That was in reference to me seeing him give his own cousin head. I reckon he was embarrassed and that he wanted to know. Basically, he didn't necessarily tell me that he wanted to know this, but I think he feared that I would expose him to somebody.
Hold on. Stay.
Just let us know what you said and what was in your mind.
What was in my mind was that he just wasn't someone that I would want to be around necessarily. That's not normal to do something like that. You know, it's your cousin. It was crazy to me. I couldn't really fathom it, but.
Now, on that day, the 18th, that Sunday, how many times did Mr. Sykes call you before you actually answered?
He actually called quite a few times. He also sent messages. And as long as I'm present on the app itself, I can't mute his notifications. As long as I'm on the app, it's going to show up anyway, unless I go and disable it, which I never really got to that. But it just kept showing up on my screen. So I slide onto our chat, and I see he's just sending a bunch of messages about, please pick up, we have to talk. And I pick up the phone. And while I was on the chat, actually, which was when he called, once he called me on the chat while I'm viewing the chat, my camera automatically turns on. And so he can see me and I can see him. And so whether or not I answer the phone or decline the call, he's still seen me while the phone was ringing, as long as I'm present on the chat. And so he's seen me, I seen him, so I'm like, all right, I might as well just pick up the phone. I picked up the phone, and he's just going off about how, he's embarrassed. I shouldn't have seen something like that, and he wanted to know if I wanted to smoke and kind of talk about it more. And I didn't want to do it. Figured he was trying to get into in my opinion, it seemed based on his wording and how he conducted himself in that situation that he wanted to.
Objection.
Just stick to what you know and what you heard and saw. So after he made this apology, what did he say next?
He wanted to know if I wanted to smoke with him and talk about it more, and I told him I didn't want to. And that's when he kind of got quiet for a second, and he had seen my face on the phone. I'm just looking. I'm like, is that all you had to call me for? And he was like, well, are you good? Like, what's going on with you? And the situation was still fresh, even though it had happened 2 days prior. It was still fresh to me, you know. Life or death situation. I was all over the place. And I told him, you know, I had said that I had almost died last night, but I know what I had said last night. That was just letting you know that I really was all over the place. I had said last night, even though the day before I was with Antoine Bryant, which also actually, this phone call occurred on Sunday, the 18th, I believe, and he actually said that we met up on Saturday, the 17th, at around 4 o'clock, from what I remember from his testimony when he had gotten off of work, 4 o'clock, that he came and met me at my mother's apartment in the parking lot. But that's one thing that he said that didn't really add up. He said that we met up to smoke.
Objection, Your Honor.
I'll keep a minute. Let's just talk about the call. So he asked you how you were, and how did you respond?
I told him that I had almost died last night. Excuse my digression. I apologize. I had almost died that last night, even though it wasn't the night before. I was just mixed up with my timing. I told him I had to shoot him. I never said them. 2 people ended up hurt, and nowhere did I reference me harming 2 individuals. Nowhere did I mention me harming 2 individuals inside of my mother's vehicle. That's evident. State's evidence does not imply that at all.
Objection.
Stick to what you said.
Mr. Ross, you may only testify as to what you've seen, what you said, what you heard, all right? Not speculate about what people thought or were thinking, all right?
Okay. And so after you made that statement, what happened?
I'm sorry.
After you told Mr. Sykes this?
Well, after we had gotten off of the phone, that was pretty much it until I was on the way to Raleigh. He had sent me a screen capture of the images of Devin Clark and Lyric Woods. That was when I had found out who she was. And he said, "What the F?" Asked me if I was all right, and I said yeah.
And that was the last time you spoke with him?
Yes, to my knowledge, yes.
And on this time when you're communicating with him, either by the video chat or by text, that's all through Snapchat, is that correct?
That's correct.
And your understanding of Snapchat when you use it, once you send a message.
Objection.
This is based on his use of the app. Okay. When you use the app and you send a message, what happens?
When I send a message, when anyone really sends a message on the app, you have the option to save it right then and there, unless the chat has been on preset settings. You have the option to save it right there or not save it and the messages that were sent that aren't saved will be automatically terminated upon swiping out of the chat itself. So everything just kind of erases.
And so you as the user have the ability to save these messages?
Yes, yes. Both from both parties. Either I could save I can save my messages and his messages, and it's vice versa.
Okay.
And if you don't save it, they terminate. If you do save it, they stay there for as long as until someone deletes them or unsaves them, and yeah.
And that early morning or night of the 17th, you were invited out by Devin. Is that fair to say?
Objection, leading.
Same.
Who invited you out on the 17th?
I was invited by Devin Clark.
Who brought the firearm that night?
Devin Clark.
When you got out the car at Buckhorn Road, who shot Lyric Woods?
Devin Clark shot Lyric Woods.
And after he did that, what did he do to you?
He came over to me with the gun, pointed it at me, and said that I knew what time it was, which would mean he's about to kill me.
Objection.
He was about to kill me.
Hold on.
I'm going to overrule it. It's his perception of the event. You may continue, Mr. Ross.
He was going to kill me, and I had no other choice. It was a life or death situation. If I would have sat there, I would have been dead. And whether or not, I'm sorry, I was about to
That's fine.
speculate again, I guess.
That's fine. Just
You can talk about your perception of what you perceive. That's all right. You can't speculate as to what other people are thinking, okay?
I would have died.
thank you.
I would have died. If I had sat there and let him do what he was going to do, I wouldn't be here speaking to you guys right now.
One moment, Judge.
Yes.
Am I allowed to keep speaking?
No further questions, Judge.
All right, Mr. Ross, cross-examination.
Thank you, Your Honor, and good morning, Mr. Ross.
Good morning.
So you and Mr. Blackwell had a falling out about a year before this incident, is that right?
That's not correct.
How long before?
Actually, we had just went on a family trip prior to that falling out. I would say it was the same year of 2022, not long before this incident occurred.
Okay. And turning to this incident, you picked Devin and Lyric up and drove them to the area where their bodies were ultimately found. Is that right?
That sounds about proper, yes.
And you got out of the car. Is that right?
I did get out of the car.
And you were using Devin's vape pen at the time, right?
Yes, that's correct.
They remained inside the car at that time.
Well, not necessarily. When I had gotten out of the car, Devin also gotten out of the car, and that was to transfer to the back seat where Lyric was.
Yesterday you testified that you didn't see that happen, but you thought you heard a car door open, is that right?
Yeah, we pretty much got out at the same time. After he handed me the pen, we both got out, and yeah.
Did you see it or not?
I didn't watch him get out of the car because I was getting out of the car myself.
And so you waited some distance away from the vehicle while they presumably had sex. Is that right?
That's correct.
And you were on your phone at that time?
Don't really recall. I'm pretty sure. You know, I had my phone. I'd have just been scrolling on my phone, using the vape pen.
Then you saw Lyric get out of the driver's side rear door and Devin get out immediately behind her.
I'm sorry, you said driver's side rear door. That's the back left. Yes, that sounds about proper. Yes.
And you believed that they were arguing. Is that right?
Well, before they had gotten out of the car, there were muffled sounds. It sounded like not normal, like a not normal voice level. But once the door opened, I could hear better. They were arguing.
After Devin shot Lyric, he approached you and asked you if you were ready to go. Is that right?
He asked me if I was ready to go and if I would be quiet about him killing Lyric. And I said, heck nah, like, this is your crap. Deal with it. I'm gonna leave. You can deal with this on your own.
And so then he pointed the gun at you?
Yes.
And you lunged for it and also attempted to headbutt him at the same time?
Yes.
And then you got control of the gun and started shooting Devin, is that right?
Yes.
And Devin started moving away from you toward where Lyric fell, is that right?
Well, the shots that I fired were pretty rapid. It wasn't just like a boom, boom, like that. I just fired the gun. He turned, and he fell a short distance away. I didn't shoot him anymore.
So could you see whether he was facing you or facing away from you when you were shooting?
Yeah. It seems like when I had first gotten control of the gun, after he had punched me right here, as soon as the barrel looked like it was turned towards him, I started firing the shots. I couldn't really see if I was hitting any of them or not. But yeah, it was pretty dark outside, and I don't really have the best vision, so.
Okay, and then he fell face down on the ground, is that right?
Yes, that's correct.
And you went to go get back in the car but realized that you might run over his legs if you pulled forward, is that right?
That's correct.
And so you took off your camo jacket and took off your quarter zip. What color was that again? I didn't get it yesterday.
It was black.
Okay.
It's a black Under Armour quarter zip.
So you took that off and used it to move Devin's body, is that right?
I had originally tried to pull him while he was still face down, but it was kind of hard. So that's when I had removed my quarter zip and threw it on top of him and pushed him over so that he would be face up.
And then you dragged him so he would be out of the road?
Yes, that's correct.
Is he still alive when you did that?
No, he wasn't.
Was he breathing?
Not that I know of, no. I know I seen his eyes were kind of still open when I had flipped him over. His eyes were kind of still open, and I noticed his mouth was also slightly ajar, and he looked dead.
Did you check for a pulse?
I didn't.
Was Lyric still alive when you were doing this?
No.
Did you check?
I didn't, but given the fact that after he had shot her, she was still alive for a minute because she was kind of rolling around on the ground. And after that altercation had happened with me and Devin, she wasn't moving or making any sound anymore.
So when you left to go get gas, Devin was laying face up near where Lyric had fallen. Is that right?
That's correct.
And was Lyric face up or face down?
Lyric, I believe, from what I remember, she was face up.
So you left, you realized that you still needed to get gas. So you went to the Petro, right?
I did.
And on the way to the Petro is when you realized Devin's bag and his other belongings were still in the car. Is that right?
That sounds about proper.
And so you took the bag, the gun, his phone, the vape, any other items he had left behind, and you threw them out of the car into the woods on Buckhorn?
Yeah, I had the vape in my pants pocket, but his phone and the gun were on the seat and his bag was on the floor. I just got out of the car and chucked it into the woods.
Okay. Then you're at the Petro, you get gas, we saw that on the video. And then you went back to the scene because you realized you forgot the quarter zip. Is that right?
That's correct.
And you went back there, you picked up the quarter zip, and then you left and went home?
No, when I had grabbed the quarter zip, it was still near the bodies. And when I had seen them again, I kind of got sick, and above them, somewhere above them, I had just started, I thought I was going to throw up. I was kind of just gagging and spitting, that kind of thing. But it was pretty bad.
But you got your quarter zip.
I did.
And then you headed home.
I did.
Now, when you got home later in those early morning hours, did you send any messages back to the group chat that Devin had originally reached out to you on?
I don't really recall.
Okay. Do you have the Snapchat handle DRXIPPY7?
Yes, that was my older handle. That was my older username itself. Later on, I had changed it to POURTRIS. I'm not really sure why it still showed up as my older handle, but
okay.
Yes, that was me, yes.
So at 3:52 a.m., the message from that handle, DRXIPPY7, to the group chat says, I was slump. Did you send that message?
Yes. Now that you say that, it sounds about proper, yes.
And what does slump mean?
Asleep.
And then just after you sent that message, you sent a message that said, nah, I don't got my wheel yet, and my mom never trying to let me wheel her SHII. Did you send that message?
I don't really recall, but evidently.
Podium mic check. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Nothing further, Judge.
No, Your Honor, thank you.
Mr. Ross, step down, please.
Yes, ma'am.
All right, will there be any other evidence on behalf of the defense?
No, Your Honor, thank you.
Ms. Russ,
Yes.
state in a moment, or do you know what you?
I will not present any rebuttal evidence, Your Honor. Thank you.
All right, ladies and gentlemen. All right, all of our members of the jury are outside of the courtroom. Before we get, well, anything we need to address right now?
We do now, Judge. I was tasked with doing something last night in reference to Defense Exhibit 1, and I did not give it to you before we brought the jury in. I do have copies for Madam Clerk. I have a copy for the state and for the court if they like. I felt like I should give it prior to doing my task at the close of state's defense.
I think that's a good idea.
Thank you.
Thank you.
Thank you so much.
Thank you.
And if there are any questions, the original is still in the back room. But yes, Judge, now at the close of all evidence, the defense renews their motion to dismiss. I believe now the burden is shifted. There's evidence that would show that Mr. Ross did not kill Lyric Woods, and there's also information that shows that his actions in reference to Devin Clark were justified. We would at this time ask that charges be dismissed.
Thank you, Mr. Trapp. Unfortunately, at this point, the burden doesn't actually shift. I have to take the evidence in the light most favorable to the non-moving party. It's a totally different issue when we get to self-defense. But at this point with the motions, again, need to view all of the evidence in the light most favorable to the state when making this decision. I will respectfully deny the defense motion. I will find at this point, although certainly have been other issues that have been raised, there is still sufficient issue on or evidence on each and every element the statement is proved for first-degree murder. To proceed to the jury, I will note the defendant's exception to my ruling. If I didn't note it earlier, I think I did. I will also note your exception to my earlier ruling as well.
Yes, Judge.
All right. First, let me go through the non-substantive instructions. So we're going to hold off on the substantive one. We'll deal with that all together. I've already added one based on the defendant's testimony. So are you all with me so far?
Yes, Your Honor.
All right. Be giving 101.05 function of the jury, 101.10 burden of proof and reasonable doubt, 101.15 credibility of witnesses, 101.20 weight of the evidence, 104.05 circumstantial evidence, possibly, I'm not sure, we have to discuss this, 104.50 I don't know that we actually had anything introduced simply as illustrative.
I believe defense one.
All right. Should we call that a diagram? Would that be fair?
Yes, Your Honor.
Okay.
And I do believe all the photographs were introduced as substantive evidence.
So I'll give 104.50, the diagram that was introduced during the defendant's case. 104.50, photographs and video as substantive evidence, since we had 2 videos, I believe.
Yes, Your Honor. 3.
3 videos. 3 videos and the photographs were all introduced substantively. I don't think there was anything else that the state introduced that would fall into these categories.
I don't believe so, Your Honor.
All right. 104.65, the stipulations between the parties. 104.94, testimony of expert witnesses. I'll be adding 104.60, which is admissions, which would be if you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, then you should consider all of the circumstances under which it was made in determining whether it was a truthful admission and the weight you will give it. I don't know if either party has an objection to that. Normally that's given because admissions are made outside the courtroom, but there certainly were admissions made in court. Either party have
I was going to request that instruction, Your Honor.
any objection?
No objection to that, Judge.
All right, so before we get to the substantive offense, let me start with the state. Are you requesting any other non-substantive instructions?
Yes, Your Honor. I'm requesting 104.10 motive. I'm requesting 104.20 testimony of interested witness. I'm requesting 104.36 flight in first-degree murder cases. I'm requesting 105.20 impeachment or corroboration by prior statement.
Okay.
I'm requesting, sorry, I skipped one. I'm requesting 104.70 confessions. And 105.21 false, contradictory, or conflicting statements of the defendant.
105.21.
21.
Let me clarify a couple of the ones that you're asking for. Impeachment or corroboration, 105.25. Who does that apply to?
Mr. Sykes, Your Honor.
104.70.
To the defendant, Your Honor.
Hold on just one second. So, confession instruction deals, it looks like, mostly with confessions that occur while somebody's in custody.
It does, Your Honor. I was reviewing the case law and I could not find anything for that one or for 105.21. I could not find a case where it involved a statement made to another party other than a law enforcement officer. And it was not clear to me from the pattern instructions that it having been to a law enforcement officer was required for that instruction, or if that's just the way the case law has generally shaken out on this particular issue. I do have a couple of cases regarding the that have interpreted this instruction and where they have found it to be appropriate, that I'm happy to share with the court and with the defense as well.
I'm assuming those cases, though, again, are dealing with custodial interrogations versus statements made while testifying.
If I could have just 1 second, Your Honor.
Yeah.
I've got a couple of cases here. Both of the cases that I do have do involve statements to a detective and then an inspector, respectively.
All right, I'll think about it. 105.21, conflicting statements. Who is that applying to?
Yes, Your Honor, it's conflicting statements of the defendant, false, contradictory, or conflicting.
All right, let's talk about that because what are you contending were the false or conflicting statements?
The version of events that he provided to Christian Sykes and the version of events that he told the jury here in court. Again, all the case law on this involves a prior statement made to law enforcement rather than to a non-law enforcement witness.
Okay. All right. Mr. Trapp, let's start with probably the easy ones. Any objection to 104.10 motive?
No objection to that.
And 104.20 testimony of an interested witness?
No, I believe that's appropriate.
All right, let's do the hard ones.
Yes.
104.36, the instruction on flight. Do you object?
I do object, and I'm going to pull it up so I can have the language in front of me. I had 104.70 in front of me at the moment.
There's only one addition to that, just a sentence that says, further, this circumstance has no bearing on the question of whether the defendant acted with premeditation and deliberation. That's the only difference.
Yeah.
Let me just hear from you, Mr. Trapp, as to
Yes.
why you think that the flight instruction is not appropriate in this case.
Well, I just want to make sure I saw the language before I responded. In this instance, the evidence would show that Mr. Ross and these three individuals went to some location that was at the
Flight
direct.
would be after the crime.
Yeah, yeah. And so after these things occurred, Mr. Ross wouldn't have had a reason to remain where he was at this location. And typically when we're talking about flight, they're running away from someone or something. And
I'm
my
going to
hope,
imagine the state's contending his going to Delaware is the flight.
and I think that there's evidence that would contradict that. Mr. Ross was told to leave. He was not allowed to stay at his location. In fact, he was told to go stay with his father in Delaware. And that's why he got this ticket. And that was testimony both from Mr. Ross and from Mr. Bryant. And that could create some kind of confusion with the jury or contradict what is in evidence that his reason for going to Delaware was to get away from this situation versus not being able to stay at his residence.
Yeah, Ms. Orr, it seems like as of right now, the uncontradicted testimony presented by the state as well as the defense is that it was not that he chose to leave, but that his mother told him to leave. And so I think the flight instruction requires that he do something in order to avoid apprehension or detection.
That is true, Your Honor. However, the case law also states that the fact that there may be other reasonable explanations for defendant's conduct does not render the instruction improper. And it's not just the leaving from North Carolina to Delaware that would support this instruction. What the case law requires is that the court may properly instruct on flight whenever there is some evidence in the record reasonably supporting the theory that the defendant fled after the commission of the crime charged. There must also be evidence that the defendant took steps to avoid apprehension. The bar for this is low. And such steps may include an action that was not part of the defendant's normal pattern of behavior. Your Honor, and additionally, for the record, that is State versus Reed, R-E-I-D, and that is 25 NC App Lexus 835. Additionally, Your Honor, in State versus McCormick, M-C-C-O-R-M-I-C-K, 837 SE 2D 383. The court, referencing another case, but also holding in this case, stated that in State versus Anthony, our Supreme Court held an instruction on flight was proper, where after shooting the victim, the defendant immediately entered his car and quickly drove away from the crime scene without rendering any assistance to the victims or seeking to obtain medical aid for them. I think that's completely what the evidence in this case would support. Additionally, Your Honor, in McCormick itself, the evidence showed that the defendant shot the victim multiple times and then fled the scene, but that he also then took other steps to avoid apprehension, including discarding the weapon and running from a traffic stop that was attempted to be conducted on him. Case law also supports the idea that taking steps to avoid apprehension is part of considering the flight instruction, and I would submit that the defendant took those steps. By his admission, he discarded evidence in this matter that he took from the scene. He also then sent a series of messages trying to obfuscate his, that he was even there at the scene at the time. And so I do believe, under all these circumstances, that the flight instruction is appropriate. I also believe that there is an open question of whose suggestion it was that he go to Delaware. I believe Mr. Bryant testified that it was Isaiah's suggestion, not his mother's suggestion. He said his mother, Ms. Cordero, never mentioned that to him when he was over there before he picked Isaiah up, if I'm recalling his testimony correctly, Your Honor. And so I would ask for this instruction.
Can I see that second case you mentioned?
McCormick?
Yes, ma'am.
Yes, Your Honor. Can I have a copy for the defense as well? May I approach?
Thank you. Sora, I think that your argument's closer than I really thought it was going to be. But I think that the testimony, as it came in, was the defendant did leave the scene, but he wasn't chased by anybody at that point. There was no police officers surrounding. Nobody knew what had occurred. That he went back to where he lived and stayed there. And although there may be some testimony that sort of calls into question maybe whose idea it was pretty clear that the defendant was told he had to leave. He ended up at somebody else's house. And all that, the motivation behind that was not that his mother thought that he had killed somebody, but that he had damaged her car. I'm not sure what else may have been in that mix, but that was at least the testimony that came in. So I think it's a good request, but I'm going to deny it.
Thank you for your consideration, Your Honor.
Mr. Trapp, 105.25, impeachment or corroboration.
Two zero, Your Honor.
Sorry. 2-0. Yes. All right. Understand I won't use Mr. Sykes' name in that instruction. Yes. All right. 104.70. Mr. Trapp? I certainly wouldn't give the second half of that instruction, but do you have an objection to the first paragraph?
I do, and when I was looking at the note for this is the one that originally caught my attention. It says that North Carolina General Statute 15A211 requires that a complete electronic recording be made of a custodial interrogation conducted at a police station or other place of detention in criminal investigations in relation to this. And the note just goes on further to say that this has to be some type of interview scenario or some type of statement made outside of court. This, I don't know if our conversation or that the statement that Sykes is referring to would fit this category. And I think one of the reasons is because I guess they're looking for the safeguards that confession can be actually recorded and reviewed rather than just recollected.
So it's an interesting thing because the state is, and you're not going to deny that that Mr. Ross, when he got on the stand, admitted at least one of the killings.
Yes.
So that is a confession, and the state is totally going to argue that, and they totally can.
Yes.
But I do think that the confession instruction was created and designed more for custodial confessions. But by the same token, he did sort of also confess to Mr. Sykes if the jury chose to believe him. So
I would just note that as I'm looking through this rule and what is encompassing, the rule keeps talking about, if this was custodial, then this needs to be recorded and at a place of detention, and it can't just be out in a car or somewhere out in the street. And I think that's where I'm getting at. I don't know if it was designed for this kind of conversation on a video chat that can't be memorialized.
no, the instruction itself is pretty simple, though. I'm not sure it cuts against you. It says that the defendant, if you first they have to find that he did confess, the defendant committed the crime charged in this case, then you should consider all the circumstances under which it was made and determine whether it was truthful confession and the weight you will give it. Let me think on that one just for a minute. All right, and the conflicting statements of the defendant?
I believe that's more an argument that the state would argue at closing rather than it being a jury instruction. And I was going through my notes, I didn't see anything conflicting in his testimony either yesterday or today, and that might be more an opinion or perception that can be argued at closing based on the attorney's interpretation of what was heard and what we know. But
Well, I think the state's contending that Mr. Ross confessed to Mr. Sykes and that his statements to Mr. Sykes were then contradicted by his own testimony here in court.
Well, the statements that were made in court verified that Mr. Ross spoke with Mr. Sykes and explained what was actually said. And so we can't
your
really
own elicited testimony was contradicting Mr. Sykes' testimony about what Mr. Ross said.
I'm trying to make sure I understand your words, because I had my words going through my head too. It's my understanding that Mr. Ross would have had to say something in this rule, and then it be contradicted here in court. But what Mr. Ross did is Mr. Ross confirmed what he said and said that wasn't what I told Mr. Sykes. And I think that's a little bit different, because there isn't anything here to verify what Mr. Ross actually said then. Unless we're talking about what he actually said on this witness stand, and that's what we're referring to. I think there's a little bit of a difference in how the rule was, I thought, meant to apply.
I don't think it matters, false or contradictory statements. I think they can come outside of court or inside of court. So you have two conflicting statements. One said the defendant said X, one said the defendant said Y, which would be no different if he'd made the same statement to law enforcement and then got on the stand and contradicted that statement. So I'm going to note your objection to that, and an exception to my ruling. I'm going to include that instruction. I'm just in an abundance of caution. I think maybe that first paragraph could apply on this case, but I'm not going to give the instruction on confession. Like I said, I think it probably could apply in this case, both with Sykes and with his testimony, but it's not what that originally was designed for. I know you're probably going to argue pretty strenuously about that in terms of your closing argument, so I'm going to leave you to it.
Your Honor, would you mind if I just put a couple of things on the record about that instruction just to preserve it?
Yes, please
Thank you, Your Honor. So I would say that the sort of note with regard to instruction 104.70, the very last sentence does say, if evidence is introduced that the defendant made a custodial statement, that you give the second set of the instruction. So I think that part of the instruction contemplates a custodial statement, which would lead me to believe that the first part of the instruction contemplates something else. And additionally, the case law states that the instruction is appropriate where the record includes evidence tending to show that the defendant confessed to the charged offense. In this case, it was also a first-degree murder. And then the court goes on to say, confession is defined as a voluntary statement made by one who is a defendant in a criminal trial at a time when he is not testifying in trial, and by which he acknowledges certain conduct of his own constituting a crime for which he is on trial, a statement which, if true, discloses his guilt of that crime. And I would say that his statement to Mr. Sykes that came into evidence that he shot Lyric because she was a witness to him shooting Devin would be a confession to first-degree murder with regard to her. So that was going to be my argument with regard to confession, but of course it is in your discretion.
It's a good argument. All right. Anything else? Any other requests on behalf of the state?
No, Your Honor. Thank you.
All right. From the defense?
No, Judge. Just once we get to the substantive part, that's when I'll have more conversation.
All right. So you have no other non-substantive requests and no objections to anything else that's being proposed other than the ones you've already put on the record?
That's correct, Judge.
All right. Let's go to the substantive charge then. So I have started and submitted to you 206.10. So let's start. There are two big issues. And I almost think we have to start with the potentially harder of the two. So I am going to instruct on self-defense. And I'm assuming that that is a request from the defense.
Yes, Judge, that's correct.
All right. So, is the state asking or requesting for the aggressor doctrine for instructions? I don't know, given either versions of events, that would qualify.
I'm not sure either. I will not request the aggressor language at this time.
Yeah, I don't think under either factual scenarios that Ross, the defendant, would have been the aggressor, who then Mr. Clark or Miss Woods then reacted, and then he, yeah, I don't think that applies. Then the second sort of choice with that goes with the idea that he, though acting in self-defense, used excessive force. So, are you going to be requesting that part of the instruction?
I am, well, for the record, I'm requesting that self-defense not be given, and I do have an argument as to that, but I understand you've decided based on what you've heard. I am requesting the excessive force portion of the instruction.
All right, talk to me about your objection to self-defense.
Yes, Your Honor. So self-defense requires that the defendant, it appeared to the defendant he believed it to be necessary to kill the deceased in order to save himself from death or great bodily harm. His belief was reasonable under the circumstances, that he was not the aggressor, which we've kind of already just discussed, and that he did not use excessive force. I think the bottom two elements 3 and 4 of self-defense would get us to voluntary manslaughter. However, the courts have held that the defendant is not entitled to a self-defense instruction when he maintains that he did not fire a gun, did not intend to shoot anyone, and did not know anyone had been shot. Now, that's not quite what we have here, but it is with regard to Miss Woods. The defendant either shot her or he didn't. And so he is not entitled to a self-defense instruction with regard to Miss Woods' homicide. Because there is no evidence in the record from which the jury could find that she ever posed a threat to him. And so we sort of have to separate out then her from Mr. Clark. And, Your Honor, courts have held...
I agree with you as to Miss Woods.
This is regarding Mr. Clark.
Okay, so let me just stop right there. Are you requesting a self-defense instruction as regards to Miss Woods?
No, Judge.
Okay, all right, so, all right, now, talk to me about Mr. Clark.
Yes, Your Honor. Your Honor, our courts have held that, excuse me, let me get to the right section. There is a case, it is State versus Revels, that is 195 NC App 546. Revels is R-E-V-E-L-S. This is a 2009 case. Your Honor, in that case, it does involve a knife rather than a gun, but two women essentially were fighting. Neither one of them had the knife on their person at that time. At some point, a knife was introduced into the argument. The defendant, Revels, disarmed the victim, Strickland, and then proceeded to stab her multiple times, resulting in her death. What the court held was that while there was evidence to permit a reasonable juror to find that Strickland was killed with her own knife, and I would say in this case there's sufficient evidence that the jury could conclude that Mr. Clark was killed with a gun that he introduced to the scene, that there was no evidence as to where the knife was before it was introduced in the fight, how or by whom it was introduced, how the defendant obtained it, and then most importantly, why she believed it necessary to stab Strickland multiple times after disarming her. I've heard no explanation for why it was necessary to continue firing shots at Mr. Clark as he turned his back and left from the area of the initial confrontation with Mr. Ross. If even assuming in the light most favorable to the defendant, because that's the standard on self-defense, that Mr. Clark did in fact threaten Mr. Ross with the gun. Once he disarms him and Mr. Clark is moving away, there is no further threat to him.
It's an interesting point, Ms. Orr, because in your cross-examination, you, I think, tried very hard to nail the defendant's feet to he was facing Mr. Clark while he was firing the gun. I think during your cross-examination, Mr. Ross never said that he ever fired the gun while Mr. Clark had turned away from him. I'm assuming that's what that line of questioning was there to establish.
He did say it on his direct examination, Your Honor.
He did?
Yesterday he said, find it, that he got control of the gun, that he started shooting, that he just pointed and squeezed, and then that Devin started moving toward the area where Lyric fell, and then he fell on his face.
Yeah. I don't know if you ever testified that he fired that gun at Mr. Clark while he was facing away from him.
Well, I do have an additional argument in connection with what he did testify to today, which is that excuse me, let me find my notes. That he couldn't see if he was firing at him, and he could not see what he was firing at. That it was dark outside and he did not have the best vision. What the case law has held with regard to the self-defense instruction is that clearly a reasonable person believing that the use of deadly force was necessary to save his life would have pointed the pistol at the perceived threat and fired at the perceived threat. That this sort of vague, I was just shooting and I didn't know what I was shooting at, does not rise to the level of self-defense. And that is supported by the North Carolina case law. Specifically, that quote is from State versus Williams, 342 NC 869, a 1996 case, which I do have a copy of here as well. Courts additionally have found that the self-serving statements of a defendant that do not amount to evidence the defendant formed any subjective belief that it was necessary to kill the deceased in order to save him from death or great bodily harm does not rise to the level of self-defense. Again, once he has the gun in his hand, and I do believe his testimony supports that Devin moved away from him toward where Lyric was lying, whether that's face front or face back. He is moving away, and so he continues firing in some non-specific direction. Additionally, Your Honor, excuse me one second. State versus Rush, 340 NC 174. The court noted, this is a 1995 case, the court stated, we also note that the fact that the victim had been shot in the back of the head and thus could not have been facing the defendant when he was shot strongly negates any theory of self-defense. Mr. Clark only had one front to back shot. The other shots to him were all back to front. He could not have been facing the defendant at the time the defendant was firing.
Mr. Trapp?
I just want to make sure we're talking about self-defense for Devin Clark. Okay. There's been testimony and information that Devin Clark, and I got to look back at the medical examiner report, but I thought he was shot twice in the front and 4 entries in the back. But the idea that, that he was shooting blindly, I have read State v. Williams, and that would be a situation where an individual was not, they almost said that they weren't shooting at a particular person, they were just kind of shooting, whereas the threat that was in front of Mr. Ross was directly in front of him. And the idea that just because you take a gun or a knife or a weapon does not neutralize the threat. There's testimony that shows that Mr. Clark was a bigger, stronger individual, and he could have then regained the gun. Mr. Ross just saw Devin kill this other individual. In his mind, he believed that that was an immediate threat for his physical bodily harm. And I think it's a justified question to put in front of a jury for them to decide. And this idea that because Devin was shot in different areas, it goes to his statement, because I think the question really was more along the lines, did he even know that he had shot Devin? He wouldn't have known. And that's where the whole thing about it being dark came out. Now, when Devin eventually fell down, that's when he realized his injuries. He couldn't say if he shot him 1 time, 2 times, or whatever. I think that's what goes to the dark and not being able to see. But in his mind, at that moment, in that minute or however long it took, he thought his life was in danger, and the only way that he would survive was by shooting the gun. And I think that, put in front of the jury, could decide one way or the other. I think it's appropriate.
No case law?
I was reviewing case law as we were talking just now. Hold on one.
Mr. Trapp, the state has argued you shoot somebody in the back, you absolutely cannot be acting in self-defense.
I would like to see the case. I don't think that's the rule. I don't think it's a hard and fast rule that just because someone gets shot on the side or the front or the back, it is or isn't self-defense. And I believe that based on, we're talking about, at this point, a child who was put in a extremely high, anxious experience moment. It would be reasonable for this individual to react and respond in that short amount of time. And just because an individual who did get shot in the front, it's at least from the medical examiner's report, as well as in the back, kind of in the same location, it wouldn't have the gait.
I think that the shots that were in the front, one of them was to his foot, I believe.
And one was in his chest.
That is correct, Your Honor. I misspoke. The one to the foot was slightly front to back. The one to the shoulder was front to back. And the other 4 were back to front.
And so that would show that the threat was in front of him. And so if an individual is pulling the trigger multiple times, if the individual did turn, then this person would, or any individual for that matter, wouldn't then stop because that's still a threat. I think that if this were a difference in time, let's say there was evidence that the individual was shot and then minutes later they continued. But this is all within one succession. Even the witness who testified about the sound of the shots said that they were rapid. Boom, 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 boom. And that would show that this span of time was so short that we cannot say, oh, this first one was okay, but the next 3 were not, because they all happened in one consecutive session. And that is the moment where Mr. Ross thought that his life was in danger. The moment didn't change.
So, Mr. Trapp, your client's testimony on the stand was the defendant's in front of me. I think he testified yesterday when you were standing next to him. He was maybe a foot or 2 away, and that your testimony from your client today is it was so dark and my eyesight was so bad, I had no idea what I was shooting at or where. And that based on his testimony today is not that Mr. Clark got away from him and he was still scared and kept shooting. But in fact, his testimony was that he was shooting at him while he was still right in front of him.
I believe his testimony does justify that he did shoot him when he was close. And I don't think there's any refuting of that. And I think that might have been the initial shot here to the chest. And I believe he kept pulling the trigger to get the aggressor away. And I think what he's talking about is because it's so dark and the person's wearing clothing, you can't actually see that if or where he got shot. I think that's more along what he was talking about, not this idea that
all we have are giant insurance. It's such a random. It's a pipeline.
full conversation on the morning meeting today. They're like, just defining the feed with the sign language interpreter. Okay, sweet. Or maybe change it.
Appreciate it.
Everyone does multiple jobs.
True. I'm gonna go, yeah.
So funny with the way I wrote that too. Like, it's like, be a bad Yeah, it was so specific. Like that.
are over there, you can just scan it with your on the table. Yeah, it's a red folder, you just scan it with your phone.
Hey, Jeff. Oh, you know. Getting ready for a refill. Oh, okay. So, yeah, I was just checking out the way you did the rest.
Premeditated and planned for this to happen on this timeout to have sex, but that he acted in malice in doing so.
So here's the problem. So in the factual record, either the defendant, for a potentially unknown reason, just shot Mr. Clark and Miss Woods, or he was acting in self-defense when he shot Mr. Clark. I don't know.
Were there in between?
Yeah, I don't know that there's any evidence of anything in between.
Well, because the state's theory doesn't really give an idea of what was surrounding this interaction, that might be why a jury would find that, because they don't have those details, and that's where I'm saying that they could see based on the scene. And keep in mind, we are not asking for a second-degree conviction, but I think that the jury could look at that and say, all right, well, we don't think it's first degree. We don't think it's premeditated and deliberated and with malice altogether. But we do believe that there was malice shown in some way based on the definition that the court provides, if they do, in regards to what malice is. And if they don't, what they believe what it's described as. But if the state does not want it, and if the court is not inclined, the defense sees that understanding.
All right. As to Miss Woods, Mr. Trapp, are you requesting any other instructions other than first?
No.
Ms. Orr?
No, Your Honor.
All right, that seems to fit. All right, we're going to take a recess for 15 minutes. When we come back, I will get you my final ruling and the jury instructions. We're running up against lunch, though, so let me ask each of the attorneys again. I'm not going to let you go for 3 hours, but give me some idea of generally, I'm not going to time you, but how long you think your closings will take.
I anticipate less than an hour.
Are you going to get both opening and closing?
Just closing.
Just closing, all right.
And, Your Honor, I believe mine will be less. I think we might be closer to 45 minutes, but I know for sure it'll be less than an hour.
All right. I'm inclined to probably break around noon and have everybody come back at 1:30. That way we won't break up the closing arguments between the two and the instructions. Is that acceptable to both sides?
Yes, Your Honor.
Yes, Judge, that's perfect.
Okay. Let's give our court reporter a break. So we will be in recess for 15 minutes. Paige, when I get these done, I'm gonna need them printed off so they can look at them. Yes. What? I give them. Also, please remember, do not go to the local library to find out if they still retain all of the encyclopedias that they used to have. Don't conduct any other type of investigation or inquiry in any way. You guys have heard the evidence that you need to have in order to reach a decision. So that also means, remember, there's probably going to be a little bit of media coverage on this, so don't read anything or listen to anything. Don't allow anybody else to talk to you about this case. Don't let them talk around you about this case, all right? Lastly, you still need to keep your minds open. You have not heard the arguments of counsel, and you have not heard the law that I'm going to get you that you need to apply to the facts that you have heard, all right? You all have done fantastic. So just remember, you're still under that bubble. When you get back from lunch, you'll come back. You'll hear the final closing arguments of counsel, and I will instruct you on the law. And at that time, you'll be able to go back and begin your deliberations where you can talk to each other about this case. All right? All right. So I'm going to let you go. If you would please be back by 1:30. As soon as we got everybody back and we're ready to go, I'll have you come in here and finish out the last part of the trial. All right? All right. Everybody else, please remain seated. Ladies and gentlemen, you're excused until 1:30. All right, all of our jurors are outside of the courtroom. This is a tough one when it comes to instructions as to where to come down with this. The evidence is definitely contradictory in this particular case presented by both sides, and that creates a sort of unevenness in trying to decide what instructions should go to the jury. What I have decided on the record with the agreement of counsel as to Ms. Woods, there'll be only one instruction. That will be first-degree murder. There will be no instruction on self-defense for Ms. Woods. As for Mr. Clark, I will give first, second, and voluntary with the instruction on self-defense, with the instruction on excessive force. I still need to clean up the instructions a little bit, so what I would ask is if the parties could remain here so I can get you a copy of that, so you can look that over lunch. When we get back, I think I'm going to ask, if you don't mind, if the parties would be here about 1:15. That will give us a chance to talk about if there's anything I missed, and just confirm that the instructions have everything that we need. I do, before we go, have a couple things I want to go over in terms of what to include in the instructions. There are a number of different choices. So, if we can go to the substantive instruction of 206.10. So as to Mr. Clark, it will be under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder, guilty of second-degree murder, guilty of voluntary manslaughter, or not guilty. Summary instructions on those. All right, so first-degree murder, the elements. Second element, in determining the reasonableness of the defendant's belief. I'm sorry, I apologize. We're doing, the defendant would be excused of first-degree murder and second-degree murder on the ground of self-defense if. So we're on the second element of that self-defense instruction. In determining the reasonableness of the defendant's belief, you should consider the circumstances as you find them to have existed from the evidence, including what are you requesting, Mr. Trapp?
I didn't have the paper copy in front of me. I was trying to load it on my computer. It's still spinning.
you want to make sure your mic's on.
Sorry, Judge. I was trying to load it on my computer so I could see it, and it just opened up a second ago. So we're at first-degree murder. In particular, we're looking at self-defense. Does not right. All right, so first, the defendant, I saw the first part. So we at second?
Yep.
All right, and second, the circumstances appeared. Need to include size, age, and strength of the defendant as compared with the victim.
All right. Any objection from the state?
No, Your Honor.
All right.
I think that the fierceness of the assault, if any, is important.
I don't know. The assault you're contending is
From Devin towards Mr. Ross.
pointing at the gun. Is that
Yeah.
your?
Yes, ma'am.
All right. Anything from the state?
No, Your Honor.
I think the next parenthesis, whether the victim had a weapon in the victim's possession, that would go along with the prior point.
Anything from the state?
No, Your Honor.
All right.
I don't believe reputation is appropriate in this case. There wasn't any evidence that would go either way in reference to that. And then,
And anything else you're asking for?
no, ma'am.
All right. All right. Are you contending or asking for, Mr. Trapp, the no duty to retreat instruction?
No, Judge, I'm not.
Okay. So I will remove, beginning with further. All right. Then we're on to the elements of first-degree murder. All right, so I think this is correct. Under the definition of malice, if the state proves beyond a reasonable doubt or it is admitted that the defendant intentionally killed the victim, I think in this case, I'm going to add or it was admitted, because I think we all agree that the defendant's testimony was he did kill Mr. Clark.
Yes, ma'am.
I'm going to go in the second element. I'm going to go with injury instead of damage. Any objection?
No objection.
All right. I was not going to give the information about proximate cause in the parentheses because it's kind of redundant. Clearly was killed by the gunshot wounds. Is that good with you, Mr. Trapp?
Yes, ma'am. That's direct and concise.
All right, so the fifth element, second paragraph, begins with neither premeditation nor deliberation. They may be proved by circumstances from which they may be inferred, such as, I guess this would go to the state.
Yes, Your Honor. I would ask for lack of provocation, conduct of the defendant before, during, and after. I had crossed out threats and declarations, but of the defendant, so I would ask that that one be left out. Use of grossly excessive force, I would ask to include infliction of lethal wounds after the victim is felled. I would ask to include brutal or vicious circumstances. I would ask to include manner in which or means by which the killing was done. I would ask to include, and I would ask to exclude ill will between the parties.
Mr. Trapp, objection to any of those?
Well, I'll let the court know I agree with the two that she excluded. I think the one parenthetical about affliction of lethal wounds after the victim is felled, I don't know if there is any evidence to show that they were shot after they had fallen.
I don't know that I have any good evidence on either side telling me when the wounds were inflicted and where the victim was.
But that, I don't know if that, I feel like we need evidence or information to support some of these instructions. And that one,
I'm going to
almost infer.
deny your objection. I'm going to note your exception to that. I'm going to find that evidence that since the victim was shot in the back, and the defense is contending that some of those shots were made while Mr. Clark was apparently running away, or the concession he was moving around the car, would support that instruction.
Okay.
Next one. Objecting to the brutal or vicious circumstances of the killing.
I know this is obviously a sensitive subject, but based on the evidence, we know that this was, at least for Mr. Clark, shots that weren't at close range. I don't know if, no objection. I believe that there's enough evidence from the state to argue one way or another.
And the final one, manner in which or means by which the killing was done.
No objection.
Okay. All right. All right, so under the voluntary manslaughter instruction, there's that whole paragraph on the heat of passion. Are you requesting, Mr. Trapp, that instruction with voluntary manslaughter?
No, Your Honor. I believe that implies a different kind of fact pattern.
All right. State have any comment on that?
No, Your Honor.
I think I'm inclined to take all of that, since the heat of passion is not something that I don't think would apply
That's correct.
under the evidence that's been presented. I'd be inclined to take that whole sentence out and just begin to find the defendant guilty of voluntary manslaughter. Would that be acceptable?
Yes, Your Honor.
Does that make sense? So we would go right from, if the state must prove that the defendant, oh, that comes out, sorry. The state must also prove that the defendant did not act in self-defense. Eliminate the rest of that sentence.
Okay, I see it now. Yes, Your Honor.
And then go right to, for you to find the defendant guilty of voluntary manslaughter, the state must prove three things.
Yes.
All right. Does that sound good to both parties?
Yes,
And
Your
then
Honor.
Your Honor would take out the sentence, a killing is not committed with malice if the defendant acts in the heat of passion, and then straight to the elements.
Yep, go right to
Perfect.
the elements. Let's go to the third element of voluntary manslaughter. I would have that third element read that the defendant did not act in self-defense, or, though acting in self-defense, used excessive force. Everybody agree?
Yes, Your Honor.
All right. Taking out of the next paragraph anything about the aggressor. The state proves beyond a reasonable doubt the defendant, though otherwise acting in self-defense, used excessive force. The defendant would be guilty of voluntary manslaughter. Yes?
Yes.
Yes, Judge.
Take out all of the language on involuntary. All right.
Did you say on involuntary?
Involuntary, yeah. Sorry. Final mandate. Take out all of any of the aggressor language. All right. I should do it. I'll get, if you all will stay, I'll ask our wonderful clerk if she'll print off a quick copy of this so you can take it with you. Is there anything else that you wish to address before we take the lunch recess?
Your Honor, the fourth paragraph under the final mandate in the draft discusses the heat of passion. I just wanted to,
I'll make sure that gets eliminated.
thank you.
All right. Anything else, Mr. Trapp?
Nothing from the defense. Thank you, Judge.
That's what I see right now, Your Honor.
All right. We'll be in recess until, let's just come back at 1:30. That way everybody has a chance to get lunch and review everything. And then we'll address any changes or adjustments we need to make to the jury instructions. Everybody ready to go on closings?
Yes, Your Honor.
Yes, Judge.
Okay. So, Mr. Trapp, you're going to start.
That's correct.
All right.
I do have one screenshot from the Petra video that I intend to use during my closing. I will mark it and put it in evidence after I use it, if that's acceptable.
Yeah, I don't think you have to, but
Okay.
if you want to, you can.
Sure.
I mean, the whole video is in
in.
evidence, so
Correct.
as long as you're not using something that wasn't introduced into evidence, I think you can use anything you want.
Thank you, Your Honor.
All right. All right, we'll be in recess till 1:30. I gotta get it to you.
Yes, Your Honor. Just a couple on page 7. The second paragraph down, for you to find the defendant guilty of first-degree murder of Lyric Woods, the state must prove 6 things beyond a reasonable doubt. That's the self-defense language. It should be 5. Also on page 8, in the last paragraph, the first sentence, acting with malice and not in self-defense, the self-defense language should be removed. Then premeditation, deliberation, then the next paragraph. If you find at the end of the second line, acting with malice and not in self-defense. And then my only other thing was a question or a suggestion. Because there's self-defense with regard to one victim and not the other, would it make sense to separate the final mandates by victim so that it's clear that those lesser includeds are not an option for Lyric? I do see that. In that case, then I would suggest that we replace victim with Devin Clark in the second set of final mandates.
Mr. Trapp, that probably is a good suggestion.
Your Honor, I agree with what Ms. Orr said. I found the original changes, and I agree with that second one, just so it's completely clear what the final mandate is, and it's clear in the jury instruction, but just so that they have the instructions right.
Okay, I will go through and put Mr. Wood's name in that final mandate so it's clear. Clark. Clearly need more caffeine at lunch. Yes, ma'am. Trapp, you getting what you need? Anything else?
I just have a couple that I had pulled out that I need to give Mr. Trapp.
It's nice of you to do that, Mr. Trapp.
I do not have 29.
Would have been helpful, Mr. Trapp, if you let the clerk know that you needed these exhibits so she could have pulled them over lunch. So let's make sure you get everything you want now. While we're waiting on that, do you have any, Mr. Trapp, suggestions for changes or alterations to the jury instructions?
Thank you for asking, Judge. The 2 or 3 that were initially brought up by Ms. Orr were the ones that I saw, but no other additional ones.
And other than the objections you've already raised, you have no additional objections to anything that is in the jury instructions?
No, Your Honor, I do not.
I'm sending you right now. Would you print the 2 copies for each of them? Madam Clerk, do you know what they're looking for? Hmm? evidence to use during the closing. I want everybody to have everything that they need. So, Zora, are you good? You're going to need to get some, I realize, when the defendant is done.
Yes, Your Honor, but I have everything else I need.
Okay. All right. Mr. Trapp, do you believe that you have everything that you want out of the evidence group?
Yes, Your Honor, I do.
All right. So, as to the verdict sheets, there are 2 verdict sheets. One is regarding the charges involving Ms. Woods. The second one is the charges involving Mr. Clark. Does anybody object to how they look or how they are worded? Zora?
No objection, Your Honor. Thank you.
No objection, Your Honor. They're very clear.
Okay. We will use those. Give us just 1 second. We'll print off copy for each side, the final jury instructions. I will remove all of the headers and any remaining footnotes for the ones that are sent back to the jury. I will send that clean copy back to the jury with the verdict sheets. All right. Do you need a couple of minutes to look through the instructions again?
If you don't mind, Judge.
All right, does anybody need any more time?
No, Your Honor.
No, Your Honor, thank you.
Any further requests for changes, additions, or deletions other than the already preserved objections of the defendant
No, Your Honor.
Nothing from the defense.
and the state? Sorry. All right. Then are you ready to go, Mr. Trapp?
I am, so I'm going to attempt to do PowerPoint. Hopefully my technology works. And
Bring it up right now so we can see what we have before we bring the jury in.
all right. Is Matt.
This is blank. Okay. What's your screen look like? Okay. Make sure you can go back and forth. Okay. All right. Anything else you need to set up before we bring the jury in, Mr. Trapp? Perfect. All right. Anything else, Ms. Orr?
No, Your Honor, just if, Mr. Trapp, are you going to be writing on this board?
If you need to move so you can see, then please do. Just
Thank you.
don't stand in the way of the jury.
And if you want, I'm going to set it up kind of over there in the corner. So
Okay.
yeah.
See if I can see it from here, and if not, I'll go back there.
Can you see the PowerPoint?
I can see the PowerPoint there and there.
Okay.
And I will look around Miss Kimmel's head. Yes. No. Yes. Thank you.
All right. I think we're good. Let's go ahead and bring our jury in. The main screen has not worked the whole trial. There apparently is a request from the facility management to come and try to fix that. I have also put in my 2 cents that I would like them to do it. They have not responded yet. So outside of start hauling people in here and threatening them, there's not much else we can do. So it is clear for the record there's a television at the end of the jury box that the jury can see. So everybody in the box should be able to see both the state and the defense's visual presentations during their closings.
That's correct, Judge.
we've got all our jurors back in the courtroom. See everybody. So at this time, as I mentioned earlier, you have heard all the evidence that is going to be presented in this trial. At this time, the attorneys are going to be presenting closing arguments. Just remember my earlier instructions, much like opening statements, closing arguments are not evidence, but to assist you in evaluating the evidence. So with that, Mr. Trapp, the jury is with you.
Thank you, Judge. Ladies and gentlemen of the jury, we've spent this last week, a couple days, listening to evidence. Both the state and myself got up at opening and we talked about what we would see. We talked about what we would hear. And it was our expectation that you would hear the facts necessary to make a determination. But now we're at the close of evidence. You're going to hear from both myself and Ms. Orr on an understanding or interpretation of what you experienced. This matter that we're here for, it's nothing short of tragedy. We have two young kids that lost their lives. We have another young man who is facing one of the most serious punishments in our criminal justice system. There are no winners in this situation. None. All of us were teenagers once. All of us made bad decisions. Snuck out, broke the rules, but it didn't have such a serious consequence. All of these individuals should follow the rules. Should have been home. And now we're here today to talk about the conduct that occurred. After Mr. Ross got off the witness stand, he spoke to you about what happened on September the 18th. He described to you the idea that he was fighting for his life, that he was put in harm's way, that he was staring at the end of a barrel of a gun, not knowing if he was going to see his next day. The judge is going to give each of you a set of instructions. I'm going to talk about those instructions. The state is going to talk about those instructions. But these instructions are like your roadmap. These are the things that you are going to follow in order to make a determination on Mr. Ross's innocence or guilt. The charges that he has in front of him are first-degree murder. That is the unlawful, intentional killing of a human being with malice, premeditation, deliberation, and of course we will include with a deadly weapon. Now, malice is the unlawful taking of the life of another without, I repeat, without justification or excuse. Second-degree murder is the unlawful, intentional killing of a human being with malice, but without premeditation and deliberation. Now, premeditation, a person must form that intent to kill over some period of time. Not instantaneously, but more like a plan. And lastly, voluntary manslaughter, the intentional killing of a human being without malice and did not act in self-defense or they used excessive force. Now, the definition for deliberation which goes back to second degree or first degree, that person acted while the defendant was in a cool state of mind. The evidence that we have heard from the experts to the officers to lay witnesses to Mr. Ross himself, it is clear that what happened on September the 17th was not planned. It was not premeditated. There was no time to deliberate. This was supposed to be a Saturday getaway where these individuals were going to have sex. That's what the plan was. And everything went the wrong direction. Now, when we're making these decisions, when we're going through all of these elements, we have to talk about an important topic. And that important topic is reasonable doubt. It's on every movie, every TV, but it's one of those words that you can't necessarily grasp. Almost like the word love, if you were to define it. What does it mean? What does it look like? How does it fit into this justice system as we decide on each one of these elements? Now, the judge is going to give you an instruction, and that instruction is going to say a reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that's been presented, or lack or sufficiency thereof. Proof beyond a reasonable doubt is proof that fully satisfies and convinces you of the defendant's guilt. Fully. Now, when I first started learning about this concept, I needed a visual, kind of comprehend and grasp what this really means in the graphic. And so, this illustration should help. I want you to imagine that this is a mouse. I put this mouse in this box with a piece of cheese. A couple seconds later, I open up this box. The mouse is here. The cheese is gone. It is simple. The mouse ate the cheese. But if I put this mouse back in this box, and I introduce a cat. And when I close the box starts to shake. And I open the box back up, and the mouse is gone. The question is, what happened to the mouse? Your immediate response is going to be obvious. The mouse ate the cheese, the cat ate the mouse. But if I told you, on the back of this box, there's a hole just small enough for the mouse to get out. That is reasonable doubt. And so when you are sitting and looking at the state's evidence and looking at the idea of first-degree murder, second-degree murder, voluntary manslaughter, and also self-defense, it is the state's job to prove every element beyond a reasonable doubt. Every one of them. Just like this mouse could have, would have, and should have gotten out of that hole. That is what you're looking at. Self-defense. That has been talked about a lot in this case. It is an idea that exists in most people's minds. The idea that an individual who is in danger, in fear of their life, presented with few options but to defend themselves. Now, this case started out with a picture of two individuals laying in a secluded road. They were positioned in a way with multiple gunshot wounds. At first blush, there was no understanding, no expectation that self-defense was even an option. the evidence progressed, and we started looking at the fact that there was only one firearm, the expert from the state made that clear. All these shell casings had the same tool marks. But then we further got more information that that firearm was a 9mm, and that that same day or shortly thereafter, a 9mm gun belonging to one of the victim's fathers was missing. It was not a coincidence that gun was missing. That firearm was brought to the scene by Devin. Even before Mr. Ross testified, that was the idea, that was the thinking. Even from the investigator, when he got on the scene, he believed that Devin Clark's father's gun was used in the commission of this act. So one question may be, why, if these kids were just going to have sex, would Devin bring his father's gun? But then more importantly, why would Issiah Ross, who knows Devin to an extent but doesn't know Lyric, have any issue with either one of them? But Mr. Clark, according to Mr. Ross's testimony, had some heated conversation with Lyric Woods. So much so that he took this gun that he brought and shot Lyric. And then he took that same gun and turned it on Mr. Ross. So then the question is, if an individual who has already shot someone turns a gun on you and points it in your face and threatens to do the same thing to you, does that meet that code? Meet that point of self-defense? I submit when you get your instructions from the judge and you put all these facts together, it will be clear. Now, Mr. Ross, on September the 17th, 2022, was a 17-year-old high schooler at Eastern Alamance High School. As we just talked about, he had a gun pointed at him. He was unarmed. In this altercation, and this was discussed by the medical examiner, Mr. Clark had abrasion on his lip as well as on his ribs. He busted Devin's lip during the struggle. Devin had multiple gunshot wounds, but he had one in the front by the chest. He had another in the front on his foot. And then he had 4 others that came around the back. When Issiah was on the witness stand testifying, after he struggled and got the gun, he fired. Bang, 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 bang. Witness James Rogers, whose house is right across the street, described the shooting. He said first he was awoken. And he didn't know what it was, but he had heard something, a bang, fireworks, the like. Started to go back to sleep, but then he heard a succession of 5 shots. Bang, 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 one after the other. This was not a stop and wait situation. This was an immediate reaction to an immediate threat. Mr. Ross testified. He said, I was scared, I was shocked, I didn't know what to do. He was in fear of his life. I asked Mr. Ross, what about Devin? What was his stature? What was his size compared to you? He mentioned he was about 6'1", 6'2", 200 plus pounds. Mr. Ross, he's not even breaking 150. So we have a bigger, stronger individual with a gun who's just shot and killed someone, pointing a gun at him. And then the next question is motive. Motive is going to be one of those rules that the judge is going to bring to your attention. And we had talked about that a little bit at jury selection. And judge is going to say that the proof of motive for the crime is permissible, often valuable, but it's never essential for a conviction. If you are convinced beyond a reasonable doubt that a defendant committed the crime, the presence or absence of motive is immaterial. It may be shown by facts surrounding the act if they support a reasonable inference. But when you all are piecing together this story, trying to figure out, has the state satisfied your questions? Have they satisfied you beyond a reasonable doubt that Issiah Ross killed Devin Clark and killed Derek Woods? This is going to keep coming back. It's going to keep coming back to the idea of, well, what would happen? Because there's still no clear story of what happened. Now, here are a list of all the witnesses who testified. First, we had Joseph Kaiser and Jordan Wilson. Those were the two individuals on the four-wheeler who located the bodies on the 18th when they were going to check their cameras for the deer cameras in the woods. And they said that this was their first time, they had never hunted this area before, and that before they even got there, first it was Joseph, he saw the bodies and he made like a shriek, and then Jordan saw it, and as soon as he saw it, they hightailed out of there. We have Elizabeth Kennedy, that is their mother. Dexter Clark, that's Devin's father. They testified about the last moments when they saw their children and their responses to what happened once they got this information. And then our first officer to testify was Officer Suzanne. Now, Officer Suzanne was one of the ones to first get on scene, and I think you remember that he was the witness who at first said, oh, I think I might have driven on the scene, and then they put a body cam up, and that body camera footage showed that he hadn't actually driven on the scene. He stopped just before he got to the right place. Investigator Baldwin, he is their evidence tech. He's the guy, when he got there, he put down all the placards, located the evidence, packaged it up, and he's the one, whenever evidence is found, they would turn it into him. James Rogers. James Rogers is the individual who lives right across the street. I just mentioned to you, he was the one who heard the shots. He was going to the beach the next day. He did tell his son about it, and I believe law enforcement contacted his son, and then he let law enforcement know that his dad had told him about these shots, which gives us the timing of these shots. Just before 2 and shortly after 2 a.m. on the 17th. Dr. Lauren Scott, she was the one who did the autopsy. And she was the one who did the exams of both Lyric and Devin, and showed you the wounds, explained to you the cause and manner of death. Walter Villa, another officer with Orange County Sheriff's Office. He mentioned that he was on scene on the 18th, but he was the one who got a call that there was a phone cord that may be at the scene, but when he got there, never found the phone cord, but found that last shell casing. Now, Jeff Bray, we'll come back to him. Dawn Hunter, she was the one who interviewed Mr. Sykes. She was on scene on the 18th, and she gave a little bit more description of what the bodies looked like and how they're positioned. But she was the one who called Christian Sykes and met with him in the Walmart parking lot. Now, Kyle Borland, another officer, he was the individual who went to the house and made sure that the car got towed back to the location. Antoine Bryant. Antoine Bryant is the ex-boyfriend slash stepdad slash caretaker for Issiah Ross. He got up on the witness stand and talked about his relationship with Isaiah, the fact that when Isaiah's mom first got angry with him, he took him in, let him stay in his house, fed him, even took him to the bus station, and all the while encouraged him, hey, Isaiah, just whatever you do, make sure you finish. You know, act right, do right by your mom, apologize. He talked about how he noticed the damage in the front of the car. He picked Isaiah up, he took him back to his house. That afternoon, they got back around 3:30, and Isaiah just stayed at his house until it was time to go. Now, why is that important? Well, we'll go down a couple people. Christian Sykes got up on the witness stand. And when he first got on the witness stand, he didn't remember much. He kind of understood, but said it was too long, too much time. And then the state played his interview, the interview he had with investigator Hunter. And he was talking about how he got a call, or he talked to him, so I should say. He reached out to Isaiah, and that they met up Saturday the 17th when he got off work and smoked. And one of the jury instructions is going to deal with credibility of witnesses, and that you all are supposed to bring your own common sense and normal understanding of daily life to determine the credibility of each witness. What are they telling me? Is it true? Is what they're saying believable? And what skills and what things to use to determine that? Well, one thing you look at is, are there some things that they're telling me that just don't match up? So one is, they did not get together on Saturday the 17th, because time-wise, it doesn't match up. Mr. Bryant said that he took Mr. Ross to his house. Mr. Ross said that. Another fact is that when Mr. Sykes was on the witness stand, he said that this altercation, this shooting, took place in the car. You've had a chance to see the evidence. You've had a chance to see this white GMC Acadia. There were no shots in the car. There was a bullet hole. And according to the state's own expert, there was no blood in the car. Now there is a person. His name was Solomon. He was considered one of the wisest individuals to ever walk the earth. And story says that he had a visit with a spirit or God. And he was asked, I'll give you anything you want. And he asked for wisdom. Shortly thereafter, he was presented with an issue where two women were arguing over a child. They were claiming that that child was theirs. Well, the backstory is that one of the women had a child and lost it. So she proceeded to take this other woman's child while she was sleeping. And so Solomon stopped, and he listened. Both of these women claim, this child is mine, this child is mine. And finally, Solomon said to one of his soldiers, give me your sword. I'm going to cut this baby in half, and you can each have it. And at that instant, the mother said, no, 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 stop, don't do that. You can give her the child. And at that moment, Solomon knew who the mother was. Because no mother would want to sacrifice it. And so when you use your wisdom, when you use your common sense to look at this evidence, think about what people said. Think about how they said it. Think about how things just don't add up. They don't match up. Now, we had different experts get up. Evie, Wendell Ivory. Mr. Ivory, he had several reports by the crime lab. They were introduced into evidence. There were DNA swabs, and these DNA swabs were of different parts of the vehicle. He tested the underwear, he tested people's hair to look to see where were they present. Wendell Ivory, from his DNA evidence, made it pretty clear that Lyric and Devin had sex that day, which is what Mr. Ross testified to, which is what even those text messages at the very beginning through Snapchat you guys read verified. It was clear that happened. You could see in the back of the vehicle, Lyric's DNA was on the back door handle. The back door handle that she came in through and she went out of right before that shot. When you are looking at these facts and comparing what the state's theory is to what you actually heard them testify, I believe you'll notice that what Mr. Ross tells you connects. The DNA that was found on the front of this GMC Acadia. Here and here. This would be the front right of the vehicle. Where did Mr. Ross say that Devin Clark chased her with? Down the front right of the vehicle. That's where her DNA is. When we looked at the crime scene photos, Devin Clark's DNA was found in little blood spots that were on the ground on the left side of the vehicle. Where did Mr. Ross say he had his altercation with Mr. Clark? It was on the left, on the driver's side of the vehicle. Not like what Mr. Sykes said. His claim was that this altercation took place in the car, that there was a shot that went off in between Devin's legs, and that afterwards Mr. Ross turned around and shot Lyric. That would imply there would be bullets or shots in the car, that there would be blood DNA in the car. That did not happen. But that got clarified. When Mr. Ross got up on the witness stand, he did admit that he talked with Mr. Sykes. Now, what Mr. Sykes took from that story, I don't know if it was a bad case of telephone or if Mr. Sykes was embellishing. He was told by Mr. Ross, man, I almost lost my life last night. He even told him, I had to shoot him, talking about Devin. He told Mr. Sykes that Devin shot her, because at the time he didn't know her name. Now, what he took from it, I don't know, even to this day. Now, if we want to go further and talk about Mr. Ross's story, the state brought an expert from the FBI to talk about where everyone was that night. And we had their cell phones, and we triangulated every phone at every time. We had a big blow up of where the phones were at the beginning. It was marked by the petrol station, Isaiah's house, Devin's house, Lyric's house, and the crime scene. And it's clear where Devin's phone was when this incident first happened. How his phone moved after he got picked up and went to Lyric's house. It shows Isaiah's movement from his house to Devin's house, to Lyric's house, to the crime scene, to the gas station, back to the crime scene, and home. And when we're talking about the testimony, when we're talking about the evidence, I believe that the state's evidence supports what Mr. Ross said. The messages between Lyric and Devin, the fact that she was giving them the location to meet up, the fact that she was giving them instructions on how she can sneak out and not be detected, all within the confines of what Mr. Ross said. Everything. The dialogue that Devin Clark had prior to him even reaching out to this group chat and his statements to this individual starts out with, "Hell you doing, fool? NS gang," or GNG. "Trying to get 8? That's a TN exclamation point. Laugh emoji, laugh emoji. "By who?" LMAO, that bitch, Lyric. Dennis responds, "She said she'll eat us both." And the conversation goes on and on. And that is a description of how Devin was describing her before this altercation. And then after he was unable to acquire a ride from this individual, he then went to a group chat and he messaged this: "You on wheels? Who on wheels want free buns?" Basically, smiley face emoji. That is what put this plan in motion. That is what led to a crime scene on Buckhorn Road. The law enforcement arrived and found multiple shell casings and bodies on the ground. That is what led to the death of Lyric Lewis by Devin Clark. This was not planned. This was not intended. But you heard the story. This is what happened. These two kids started the night thinking they were going to go out and have sex. And it turned out to be a situation that none of us will ever forget. The question is, who did what? Devin Clark killed Lyric Lewis. When the state was discussing the position of the bodies, one of the officers rolled Devin's body over, and underneath it was a crock. It was a crock or a shoe that belonged to Lyric. Now, why is that important? Well, it shows the order of the day. In order for Devin to be placed there, on top of that shoe, it would have to show that Lyric's shoe had to end up there first. You talked a little bit about this, but I want to make sure you saw it. So this is kind of a timeline here. We had a Snapchat message. Issiah picks up Devin after his Snapchat message. Devin has a book bag. Lyric gets in shortly thereafter. That is when Devin points him in the direction of Buckhorn Road. Issiah gets out the car. He asks, Devin, can I get your bait while you guys do what you do? And then there's the verbal altercation between Devin and him. They get out the car. Issiah hears a commotion. And then everything happens so fast. Devin runs around the car, takes out his gun, and shoots her. Boom, 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 boom. When Devin points his gun at Issiah, that is a key point. That is where Issiah, fear, adrenaline, fight or flight, takes this gun and does the only thing he thinks is possible. He shoots Devin, continues firing until he lays down or stops moving because that was his threat. He's panicking, he doesn't know what to do, tries to get in his car, realizes he can't because the road is so narrow that he can't get around him. Picks up Devin, pulls him back, and he drives off. Can't even get home because his gas tank is on it before they ever even got there. Now, when you all are deliberating and going through all these facts and scenarios, remember that you individually are to think about what you recall, what you remember, about how you interpret all this information. And if you are in that room and there are elements that are presented to you by the judge on this jury instruction, and your answer to that question is maybe, I think, probably, then your response on your verdict sheet should be not guilty. But if you go through and you listen to or think about all the facts, looking at your notes, hearing about the conversation of your colleagues, and you are sure about all of these ideas, all of these elements, yes, that is guilty beyond a reasonable doubt. But I believe that when you really stop and think about all the things that you heard, minus the emotion and the shock of what you guys have all experienced and you saw, there will be doubt. There will be some uncertainty. There will be questions that are left unanswered. The only thing we know for sure are that 3 people went to Buckhorn Road that night. 1 person left. There was 1 gun tested. 1. And Devin Clark brought it. He used that gun to kill Derek Woods and to try and kill Issiah Ross. And the only way he could have made it out alive was by taking the gun from his cap. The only way. And I believe once you've gone through that analysis together, that you will find the verdict of not guilty of the murder of Devin Clark and murder of Derek Woods. Thank you.
Mr. Trapp? Thank you. Ms. Orr?
I have just another moment, Your Honor.
Yes, ma'am.
Thank you. Thank you, Your Honor.
No problem. Ms. Orr, the jury will be with you.
Thank you. On the afternoon of September 18th, 2022, two families' worst nightmares were cemented into reality when they found out that the bodies found on Buckhorn Road in Upland were the missing teenagers Lyric Woods and Devin Clark. This case is about a choice that ended two futures. Three young people got together in the early morning hours of September 17th, and now two of them are dead. Now, the defendant chose to testify, and that's his right. But he is not a neutral witness. He is the only person in this courtroom with a personal stake in your verdict. He has every reason to explain, to minimize, to justify. He told you what he needs you to believe, not what the physical evidence proves. And when his words conflict with the physical evidence, you are not required to accept his version. Stories can be shaped. Evidence cannot. And from the defendant's perspective, he has to somehow justify two killings, or he has to completely absolve himself of responsibility for one of them. It would be nearly impossible to justify those two close-range shots to Lyric's neck as being necessary in self-defense. But by saying Devin shot Lyric, he eliminates all possible responsibility for her death. And he puts in your minds that Devin was a threat to him, thereby justifying killing Devin in self-defense. Now that's a tidy argument if it was supported by the other evidence in the case, but it's not. First, the defendant claims that the first set of shots testified to by James Rogers was Devin shooting Lyric, and then the second set of shots was the defendant shooting Devin. Mr. Rogers testified that he was woken up by a noise, fireworks, or gunshots. He wasn't 100% sure. And then 10 minutes later, he heard 4, not 5, distinct gunshots. We know from the evidence that Devin was shot 6 times, not 4 times. Now, I'm no mathematician, but even I know that's not adding up. The defendant's testimony also does not account for that 10-minute gap at all. He says everything happened so quickly, but that can't be right. Now, the defendant also testified that he threw all of Devin's belongings out of the car on the side of Buckhorn Road on the way to the Petro. But there are a few reasons why we know that can't be true. On the cash report, Devin has 61 timing advance records between 1:45 a.m. and 2:42 a.m. Roughly one per minute. And this block down here. And his phone never leaves the scene. All of those records are a consistent distance from this tower and the timing advance bands going right over the top of the crime scene. And the last time Devin's phone connects to the network is at 2:44 a.m. The defendant's phone, on the other hand, is on the scene from 1:45 a.m. to 2:14 a.m. and then it travels. And he heads to the Petro. And we know he's at the Petro from 2:20 to 2:29 a.m. Remember, the Petro video shows him approaching the cashier and he's holding his phone in his hand. And the Petro video says this is from 2:11 to 2:19, but obviously that's 10 minutes slow because this timing is going to be the most accurate timing. And we know he's there. He's on video. Now, he returns to the scene at 2:36 a.m. And he's there until 2:50 a.m. Now that encompasses the time frame that Devin's phone suddenly disconnects from the network. Additionally, Devin's vape, this vape that we keep hearing about. The defendant said on cross-examination this morning that that vape was in his pocket and that he threw it out with the rest of Devin's belongings. But the medical examiner testified, and it's in her report, that in the clothing and personal effects section, Devin's body was clad in tan pants, 2 black socks, black underpants, a black and white long sleeve hoodie and underlined white t-shirt. A vaping device is in the pants pocket. So if the defendant wasn't in possession of Devin's vape, Devin was in possession of Devin's vape. When did that happen? The defendant also testified that he moved Devin's body before heading to the Petro. He specifically said that Devin had fallen face down near the edge of the gravel and that he took off his camo jacket, removed his black quarter zip, used the quarter zip to flip Devin over so that he was face up, and then dragged him so he was completely out of the road. Now the evidence shows that Devin lay bleeding face down for some period of time before he was turned over, and that he was right next to Lyric when this happened. Remember the crime scene photos, and we discussed the 2 large pools of blood that you can see in between the bodies, depicted here by Lyric's hip and here by her foot. Now imagine you took Devin and you rolled him over onto his face toward Lyric. Those 2 pools of blood would line up exactly with the thigh wound and with the wound to his shoulder. You rolled him over face down right there, that's where he's going to be bleeding. And because those pools of blood are so large, we know he had to have been left there for some time for that to accumulate. And remember also the dusty, dirty spots on his clothing, which were inconsistent with how he was found. Now, it took approximately 20 minutes for the defendant to drive to the Petro, get the gas, and then come back to the scene. And that would explain why those 2 areas of blood exist when they don't match up with any other injuries on either Lyric or Devin. The defendant also testified that he returned to the scene after leaving the Petro to retrieve his black quarter zip that he used to move Devin's body. Members of the jury, the defendant's wearing a black quarter zip at the Petro. You can see it here underneath the camo jacket. It's a little fuzzy, You can see this shine right here in the center of the neck, and you can just barely see right there a lighter spot where that zipper would end. So you can't have left it at the crime scene, which means he didn't use it to move Devin's body, which means there must be some other explanation for all of this. In jury selection, you describe some things that are important to you in determining the credibility of a witness and what weight to give their testimony. You describe things like whether they have provided consistent statements, whether they have an agenda, whether their story matches or lines up with other evidence, and also a person's demeanor and body language. Now, this is supposedly one of the most horrible things that's ever happened to the defendant. But his affect and delivery in this courtroom was completely flat. There was no emotion at all. The defendant failed all of the tests that you described, that you use in your everyday lives to assess someone's credibility. So now that we know that the defendant's story is a fabrication, the question remains, what exactly did happen in the early morning hours of September 17th? So let's talk about Christian. Issiah was not a suspect before Christian came forward. The sheriff's office had not yet uncovered any evidence connecting the defendant to the offense. Christian did not know his interview was being recorded, and he wished to remain anonymous. And it was pretty obvious that he did not want to be here testifying. So if Christian isn't being honest about his conversation, then he just, out of the blue, decided to implicate someone that he has a casual friendship with in a gruesome double homicide. He could have easily told the deputies when they called him that he didn't have any information and kept himself completely out of it. So why come forward unless the information is true? Issiah's testimony about his relationship with Christian contradicts itself. Yesterday on direct examination, he said that he and Thomas, Christian's cousin, had a falling out, but that he and Christian kept hanging out after that. That Christian would pick him up from work and give him rides, and he described that. And today he told you that he fell out with both of them at the same time, and that he had not spoken to Christian until Christian contacted him on that Sunday the 18th. In his testimony, Issiah did not tell you what he told Christian. He said he gave him a brief description, that it was not a complete recitation, that he told him what actually took place, but that he can't really say what he said to Christian. The version that the defendant told Christian is more plausible than what you heard from him on the stand. Issiah told Christian that I capped them, that they were both going to have sex with Lyric, but he didn't provide any details about what happened when they arrived to the scene. Then he said that Devin was beating him with a gun. He told him to stop doing that once, twice, and on the third time, he was upset enough about it to try to wrestle the gun away from Devin. That the gun went off between his legs, that he got control of the gun and shot Devin, and then he turned around and shot Lyric because she was a witness. Now, Christian testified that he assumed that this occurred in a vehicle because of the phrase turned around, and also stated on the stand, on cross-examination, that Issiah never told him it happened in the car. That's just what he assumed. Now, turn around could mean a lot of things. I mean, if I'm facing this direction and I turn to face this direction, then I've turned around. And there's no evidence that there were any shots fired in the car. So although that was one assumption he made, he didn't actually say that that's what the defendant told him. Now, Christian also described that they had this conversation over video chat on Snapchat. And he said that Issiah was outside at his stepdad's house when this happened, which is consistent with where Issiah was on Sunday. He was at Antoine's house and Antoine testified that he spent most of the day outside. And also remember how Christian described the defendant's demeanor. He was laughing, that he was joking. He didn't seem to have any remorse at all, while relating that he had just killed 2 people. And he told Christian all of this without prompting and before their bodies had ever been discovered. Now, it's equally important what he does not tell Christian. He doesn't say, I was scared for my life. He doesn't say, I was threatened. He doesn't say, I had no choice. He doesn't say it was either them or me. And he does not say that Devin shot Lyric. And Isaiah confirmed that for you in his testimony. He did not tell Christian that Devin shot Lyric. Now, the version of events that Isaiah told Christian bears almost no resemblance to his testimony at this trial. One of these statements was made within 48 hours of the events happening. One was made over 3 years later, after he's had an opportunity to review all of the evidence collected by law enforcement and hear all of the evidence presented in this courtroom. Which one is more likely to be closer to the truth? So, what does the evidence show us? The evidence shows that Devin and Lyric did have sex, or at least engaged in some kind of sexual contact. Lyric's oral swabs, her underwear, and her external genitalia swabs show both her and Devin's DNA. Devin's underwear and his external genitalia swabs show both his and Lyric's DNA. So something happened between them, most likely exactly what was discussed in the messages, oral sex. Now, the evidence shows that Devin was offering for whoever was going to give him a ride to have sex with Lyric. But there's no evidence that Lyric was aware of that promise, or that she agreed to it. The defendant gave a ride under the impression that he would have a turn. Perhaps this is what sparked the disagreement. Lyric and Devin finished what they were doing, the defendant stepped up expecting his turn, and Lyric balked because that is not what she signed up for. Now, it's possible that Lyric did say what the defendant said, that she told Devin she wasn't a whore, and she wasn't going to let Devin pimp her around. What if those statements were in reference to not having sex with the defendant? We can't know for sure. You know, there's this TV show on Netflix called Black Mirror. I don't know if any of you have seen it. But it's about the interesting intersections between technology and our real lives. In one episode, there's an implant that you can get that'll record every single thing that happens to you. Or kind of like those red flag replay commercials during football games, where you can just relive an event exactly as it happened. But we don't have that luxury. We don't have that technology. So we can't know for sure what happened. But something sparked a disagreement, such that a gun was introduced to this situation. We also can't know for sure who brought the gun or who introduced it to the conflict. That is not a knowable fact. What we do know is that the defendant walks away without a scratch, and that Devin and Lyric end up dead. Now, how could this have happened? How could this have happened? If we look at the crime scene photos, we sort of have 3 distinct areas. Shell casings down here that were marked 1, 2, and 3 by the sheriff's office. You know, there's no blood surrounding those rocks or anywhere near them. Perhaps those were the first shots fired. So we have 3 shots, and maybe we assume that those are the body shots that are front to back. So that would be Devin's right shoulder, Lyric's left arm just above the elbow, and Lyric's left shoulder that entered at an angle and then exited her upper arm, as if she were turning away from the person who was shooting. Now, if those injuries occurred next to the GMC on that front passenger side, that could explain her blood on that fender and the rim there. Now, both begin to move away, and they are moving up the scene toward where we have this row of placards back here, 7, 4, 18, 5. There are 5 shell casings found along that same path right there. Placards 4, 5, 6, 7, and then the one found the following day by investigator Vila, which he described as being over here just on the edge of this brushy area near where the red slides were located. Now, somewhere over here to the left, near placard 7, is where Devin receives his foot injury. And that shot was also slightly front to back, according to the medical examiner. So imagine he's moving away from where 1, 2, and 3 are. He's moving toward where 7 and 4 are. And then he realizes he's going to run into all this thick brush here. And so he has to change direction. He could have easily gotten that foot shot during that process. And that is consistent with the blood. It starts out just a little bit here by placard 18, and it gets thicker and more frequent as we move along the scene from left to right towards placard 8 and 9, which were those other rocks with the blood on them. He loses his shoes in that tall clump of grass just beside placard 9 where all this blood is going, and then we've got the shoes here in the brush. Maybe he's urging Lyric along ahead of him. The defendant's still shooting them from behind as they make their way toward that open field. Both are hit enough times that they fall. They're unable to keep going from their injuries. Now, if you're keeping count, that's 8 shell casings. So here's the break that Mr. Rogers described. Once the 2 of them have fallen and they don't appear to be getting back up, then there's a break in the action as the defendant tries to figure out his next steps. Because now he's in big trouble. He can't afford to leave them alive. And that's the conclusion he reaches in those 10 minutes. And so then we have the 4 shots that Mr. Rogers described here. Those distinct 4 were the insurance shots to make sure that they are dead. And those are the casings that were found in the grass near Lyric's head, originally marked as 12, 13, and 14, and then upon a second examination, number 20 was also located. Right here, just above where both bodies are found. Those shots are the 2 in Lyric's neck, the one in the back of Devin's head, and either entrance wound 1 or entrance wound 2 for Devin. Those are the 2 injuries. One came through the front of his neck, severed his jugular and carotid arteries, and one entered the back of his shoulder, and that's where that projectile stopped, just above his collarbone. The defendant cannot claim self-defense with regard to the death of Lyric Woods because he claims he did not shoot her at all. But the defendant has argued that he acted in self-defense with regard to Devin Clark. Self-defense requires that the defendant believe it was necessary to use deadly force against the victim in order to save the defendant from death or great bodily harm. It also requires that the circumstances as they appeared to the defendant at the time were sufficient to create such a belief in the mind of a person of ordinary firmness, or put another way, that the defendant's belief was reasonable, and that the defendant did not use excessive force. The backs of these victims tell you everything that you need to know. Fear runs away. It does not give chase. It is consistent with the evidence that the victims were moving away when they were being shot at. Both of them have multiple gunshot wounds to the back. Now, our courts have said that it is entirely unreasonable that a person of ordinary firmness would have considered the use of deadly force necessary to protect himself from an unarmed person who was running away from the scene. Once the gun is in the defendant's hands, there is no longer any danger to danger to begin with. Once the gun is in his control, he can leave. He can call for help. But he doesn't do either of those things. Instead, he chases down Devin and Lyric. Then, after 10 minutes of consideration, he shoots Lyric and Devin while they lie on the ground, bleeding from the wounds he has already inflicted. This was not one shot fired in panic. Panic does not aim, and chaos does not explain accuracy. This was a series of choices. The choice to pull the trigger a second time, a third, a fourth, and a fifth, and a sixth, and a seventh, and an eighth. And then it's especially the 9th, 10th, 11th, and 12th. Shot after shot, decision after decision. Now, once he can be sure that they're dead, the defendant does leave the scene. He goes to the petrol, he puts gas in the car, and he still doesn't call for help. Then he returns to the scene, and why? Because Devin's phone is still there, and it contains evidence. So he had to go get it. To accomplish this, he had to move Devin's body, because Devin was face down, and his phone was in that front pants pocket. Now you can see in the photographs how Devin's front pocket is saturated in blood from that thigh wound. Remember the luminol reaction over the dome light in the car that appeared to be a handprint that was cleaned? Now we didn't have any confirmatory testing on that, but if it was cleaned, that's not necessarily unexpected. So imagine he fishes the phone out of Devin's bloody pocket, and then when he gets back in the car, he sticks his hand up there to cover that light to make sure he's not seen. The wicked flee when no man pursues. With Devin's phone secured, the defendant leaves, and the cover-up begins. He disposes of evidence. Devin's phone and the murder weapon have never been located. He covers his tracks with the messages in the group chat. First, that same night, he messages that he was asleep and couldn't get his mother's car to use, which by his own admission were untrue. Second, throughout the weekend, he's responding to messages about Devin being missing and then Devin being dead, as if he didn't know exactly what had happened to him. And then third, he makes arrangements to leave the state and he flees. It takes until October 5th for law enforcement to find him. 15 days between charges being taken out and his arrest. Now, the defendant was young, only 17 at the time of the offense. And while youth may explain immaturity, it does not excuse violence. At 17, the defendant was old enough to understand what a gun does. He was old enough to understand that pulling the trigger ends lives, and he was old enough to stop. His age does not change what happened, and it does not change your duty. In a few moments, the judge will instruct you on the law you must apply. For first-degree murder, the law requires the state to prove the following: that the defendant intentionally and with malice killed the victim, that the defendant's act was the proximate cause of the victim's death, that the defendant intended to kill the victim, and that the defendant acted with premeditation and deliberation. Malice means without just cause, excuse, or justification. Premeditation simply means the intent to kill was formed before the act. The law does not require a long time. In fact, mere seconds can suffice, as long as there was time to think. Deliberation means the act was carried out in a cool state of mind, not under a sudden, overwhelming passion. And you'll be instructed that you can infer premeditation and deliberation from the following circumstances: the lack of provocation by the victim, the conduct of the defendant before, during, and after the killing, the use of grossly excessive force, the infliction of lethal wounds after the victim is felled, the brutal or vicious circumstances of the killing, and the manner in which or means by which the killing was done. apply North Carolina's definition of first-degree murder to these facts, the conclusion is unavoidable. This was an intentional killing. There could be no other conclusion given the number of shots fired. It was done with malice, that is, without just cause, excuse, or justification. And premeditation and deliberation are shown by the repeated shots to the back, the additional shots fired after the victims had already fallen, and the defendant's conduct after the killing in trying to hide his responsibility. Under the instructions you'll receive, this was a first-degree murder. Each trigger pull, a separate decision to end a life. A 10-minute break in the action. Time to call for help. Who knows, that could have potentially saved the lives of Devin Clark and Lyric Woods. Carefully considered decision to fire 4 more shots, silencing them forever. Stories change, evidence doesn't. The backs of these victims tell you everything you need to know. The wicked flee when no man pursues. 2 lives were ended. 2 families changed forever. They'll never graduate, they'll never grow older, and they'll never come home again. This courtroom is the only place where their voices can still be heard. The evidence is spoken, and now the law asks you to respond. Hold the defendant accountable for the choices he made and the lives he took. Return verdicts of guilty. Thank you.
All right. Ladies and gentlemen, before I give you the instructions, our wonderful court reporter has been working since 1:30. We need to give her a break before she has to type down everything I say. So we're going to take a 15-minute recess. Please remember all of the rules. Put your notebooks in your chairs. Ladies and gentlemen, stay seated in the courtroom. And we'll excuse our juror for a 15-minute break. Thank you. All right, all of our jurors are outside the courtroom. Anything we need to address before we take a break?
No, Your Honor.
No, Judge, just want to make sure we get all this back to the clerk.
Make sure Madam Clerk gets it. All right, we'll be in recess for 15 minutes.
came out this door in addition to that to ask you. Who can you call to get water to the cleaners that they need to be paper? We're about out of toilet paper. Also, so we need all the paper products. Toilet paper and while we're at it, maintenance needs to fix that water valve that drives the Give it a good try.
Don't call me Shirley.
All right, I haven't heard that since Jeff Shirley.
same front door or the back steps?
All right, anything we need to address before we bring the jury in?
No, Your Honor.
The defense. Thank you, Judge.
All right, bring our jury back in, please. It's on, so. I don't think anybody's ever accused me of not talking loud enough. All right, we've got all of our folks back. Members of the jury, all of the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law that I'm about to give you to those facts. It is absolutely necessary that you understand and apply the law as I give it to you, not as you think it is, and not how you might like it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied. The defendant has entered pleas of not guilty. The fact that the defendant has been charged is no evidence of under our system of justice. When a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt that is based on reason and common sense, arising out of some or all of the evidence that has been presented, or the lack of the insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of the witnesses. You must decide for yourselves whether to believe the testimony of any witness. You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same test for truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in the case. You are also the sole judges of the weight to be given any evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in the case. There are two types of evidence from which you may find the truth as to the facts of a case: direct or circumstantial evidence. Direct evidence is testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is a proof of a chain or group of facts and circumstances indicating the guilt or innocence of the defendant. The law makes no distinction between the weight to be given either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all of the evidence in the case. After weighing all of the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. A diagram was introduced into evidence in this case for the purpose of illustrating and explaining the testimony of a witness. This diagram may not be considered by you for any other purpose. Photographs and videos were introduced into evidence in this case. These photographs and videos may be considered by you as evidence of the facts they illustrate or show. Proof of motive for a crime is permissible and often valuable, but never essential for conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus proved, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. You may find that a witness is interested in the outcome of this trial. You may take that witness's interest into account in deciding whether to believe the witness. If you believe the testimony of a witness in whole or in part, you should treat what you believe the same as you would any other believable evidence. The state and the defendant, Issiah Ross, have agreed or stipulated that certain facts shall be accepted by you as true without further proof. The agreed upon facts in this case are as follows. State's Exhibit 128 is an authentic copy of subscriber information, communications content, and transactional metadata for Snapchat app account for subscriber identifier basketball_1296. Subscriber identifier basketball_1296 belonged to Devin Clark. State's Exhibit number 134 is an authentic copy of historical cell site location information and subscriber information for phone number 243-244-0344. Phone number 743-244-0344 belonged to Devin Clark at the time of the offense. State's Exhibit number 136 is an accurate copy of historical cell site location information and subscriber information for phone number 908-440-5523. Phone number 908-440-5523 belonged to Issiah Ross at the time of the offense. State's Exhibit number 138 is an authentic copy of surveillance video from the Petro Travel Center located at 500 Buckhorn Road in Mebane, North Carolina, 27302. Since the parties have so agreed, you are to take these facts as true for the purposes in this case. In this case, you have heard testimony from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have specialized skill or knowledge. As I have instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to all the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in the case. You should consider the opinion of an expert witness, but you are not bound by it. In other words, you are not required to accept an expert witness's opinion to the exclusion of facts and circumstances disclosed by other testimony. If you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, then you should consider all of the circumstances under which it was made in determining whether it was a truthful admission and the weight you will give to it. Evidence has been received tending to show that at an earlier time, a witness made a statement which may conflict or be consistent with the testimony of the witness at this trial. You must not consider such earlier statement as evidence of the truth of what was said at the earlier time because it was not made under oath at this trial. If you believe the earlier statement was made and that it conflicts or is consistent with the testimony of the witness at this trial, you may consider this and all other facts and circumstances bearing upon the witness's truthfulness in deciding whether you will believe or disbelieve the witness's testimony. The state contends and the defendant denies that the defendant made false, contradictory, or conflicting statements. If you find the defendant made such statements, they may be considered by you as a circumstance tending to reflect the mental process of a person possessed of a guilty conscience, seeking to divert suspicion or to exculpate the person. And you should consider that evidence along with all other believable evidence in this case. However, if you find the defendant made such statements, they do not create a presumption of guilt, and such evidence standing alone is not sufficient to establish guilt. Such evidence may not be considered as tending to show premeditation and deliberation. The defendant has been charged with first-degree murder of Lyric Woods. Under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder or not guilty. First-degree murder is the unlawful killing of a human being with malice and with premeditation and deliberation. For you to find the defendant guilty of the first-degree murder of Lyric Woods, the state must prove 5 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim, Lyric Woods, with a deadly weapon. Malice means not only hatred, ill will, or spite, as it is ordinarily understood, but it also means the condition of mind which prompts a person to intentionally take the life of another, or to intentionally inflict serious bodily harm that proximately results in another person's death without just cause, excuse, or justification. The state proves beyond a reasonable doubt or is admitted that the defendant intentionally killed the victim with a deadly weapon or intentionally inflicted a wound upon the deceased with a deadly weapon that proximately caused the victim's death. You may infer first that the killing was unlawful, and second, that it was done with malice, but you are not compelled to do so. You may consider this along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A firearm is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of the victim Lyric Woods' death. Proximate cause is a real cause, a cause without which the victim's death would not have occurred, and one that a reasonably careful and prudent person could foresee would probably produce such injury or some similar injurious result. Third, that the defendant intended to kill the victim, Lyric Woods. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proven by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which the assault was made, the conduct of the parties, and any other relevant circumstances. Fourth, that the defendant acted with premeditation. That is, that the defendant formed the intent to kill the victim, Lyric Woods, over some period of time, however short, before the defendant acted. Fifth, that the defendant acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. They may be proved by circumstances from which they may be inferred, such as a lack of provocation by the victim, conduct of the defendant before, during, and after the killing, use of excessively or grossly excessive force, infliction of lethal wounds after the victim is felled, manner in which or means by which the killing was done. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, acting with malice, killed the victim, Lyric Woods, with a deadly weapon, thereby approximately causing the victim's death, that the defendant intended to kill the victim, and that the defendant acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder. However, if you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. The defendant has been charged with the first-degree murder of Devin Clark. Under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder, guilty of second-degree murder, guilty of voluntary manslaughter, or not guilty. First-degree murder is the unlawful killing of a human being with malice and with premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice, but without premeditation and deliberation. Voluntary manslaughter is the unlawful killing of a human being without malice and without premeditation and deliberation. The defendant would be excused of first-degree murder and second-degree murder on the ground of self-defense if, first, the defendant believed it was necessary to use deadly force against the victim, Devin Clark, in order to save the defendant from death or great bodily harm. Second, the circumstances as they appeared to the defendant at the time were sufficient to create a belief in the mind of a person of ordinary firmness. In determining the reasonableness of the defendant's belief, you should consider the circumstances as you find them to have existed from the evidence, including the size, age, and strength of the defendant as compared to the victim, Devin Clark, the fierceness of the assault, if any, upon the defendant, and whether the victim had a weapon in the victim's possession. The defendant would not be guilty of any murder or manslaughter if the defendant acted in self-defense and if the defendant did not use excessive force under the circumstances. A defendant does not have the right to use excessive force. A defendant uses excessive force if the defendant uses more force than reasonably appeared to the defendant to be necessary at the time of the killing. It is for you, the jury, to determine the reasonableness of the force used by the defendant under all the circumstances as they appeared to the defendant at the time. Therefore, in order for you to find the defendant guilty of first-degree murder or second-degree murder, Devin Clark, the state must prove beyond a reasonable doubt, among other things, that the defendant did not act in self-defense. If the state fails to prove that the defendant did not act in self-defense, you may not convict the defendant of either first or second-degree murder. However, you may convict the defendant of voluntary manslaughter if the state proves that the defendant used excessive force. For you to find the defendant guilty of first-degree murder, the state must prove 6 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim, Devin Clark, with a deadly weapon. Malice means not only hatred, ill will, or spite, as it is ordinarily understood, but it also means the condition of mind which prompts a person to intentionally take the life of another or to intentionally inflict serious bodily harm that proximately results in another person's death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt, or it is admitted that the defendant intentionally killed the victim with a deadly weapon or intentionally inflicted a wound upon the deceased with a deadly weapon which proximately caused the victim's death, you may infer, first, that the killing was unlawful, and second, that it was done with malice, but you are not compelled to do so. You may consider this along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A firearm is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of the victim Devin Clark's death. Proximate cause is a real cause, a cause without which the victim's death would not have occurred, and one that a reasonably careful and prudent person could foresee would produce such an injury or some similar injurious result. Third, that the defendant intended to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proven by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which the assault was made, the conduct of the parties, and any other relevant circumstances. Fourth, that the defendant acted with premeditation. That is, that the defendant formed the intent to kill the victim, Devin Clark, over some period of time, however short, before the defendant acted. Fifth, that the defendant acted with deliberation, which means the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. This may be proved by circumstances from which they may be inferred, such as the lack of provocation by the victim, conduct of the defendant before, during, and after the killing, use of grossly excessive force, infliction of lethal wounds after the victim is felled, brutal or vicious circumstances of the killing, manner in which or means by which the killing was done. And sixth, that the defendant did not act in self-defense. Second-degree murder differs from first-degree murder in that the state does not have to prove specific intent to kill, premeditation, or deliberation. For you to find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant unlawfully, intentionally, and with malice wounded the victim, Devin Clark, with a deadly weapon, approximately causing the victim's death. The state must also prove that the defendant did not act in self-defense. For you to find the defendant guilty of voluntary manslaughter, the state must prove 3 things beyond a reasonable doubt. First, the defendant killed the victim, Devin Clark, by an intentional and unlawful act. Second, that the defendant's act was a proximate cause of the victim, Devin Clark's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. And third, that the defendant did not act in self-defense or, though acting in self-defense, used excessive force. Voluntary manslaughter is also committed if the defendant kills in self-defense but uses excessive force under the circumstances. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. However, if the state proves beyond a reasonable doubt that the defendant, though otherwise acting in self-defense, use excessive force, the defendant would be guilty of voluntary manslaughter. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the defendant, acting with malice and not in self-defense, killed the victim, Devin Clark, with a deadly weapon, thereby proximately causing the victim's death, that the defendant intended to kill the victim, Devin Clark, and that the defendant acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder, but then will determine whether the defendant is guilty of second-degree murder. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally and with malice, but not in self-defense, killed the victim, Devin Clark, with a deadly weapon, thereby proximately causing the victim's death, it would be your duty to return a verdict of guilty of second-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of second-degree murder, but then will determine whether the defendant is guilty of voluntary manslaughter. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally wounded the victim, Devin Clark, with a deadly weapon and thereby proximately caused the victim's death and used excessive force, it would be your duty to find the defendant guilty of voluntary manslaughter, even if the state has failed to prove that the defendant did not act in self-defense. However, if you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. And finally, if the state has failed to satisfy you beyond a reasonable doubt that the defendant did not act in self-defense or that the defendant used excessive force, then the defendant's action would be justified by self-defense, and it would be your duty to return a verdict of not guilty. Members of the jury, you have heard the evidence and the arguments of counsel. If your recollection of the evidence differs from that of the attorneys, you are to rely solely upon your recollections. Your duty is to remember the evidence, whether it is called to your attention or not. You should consider all of the evidence, the arguments, contentions, and positions urged by the attorneys, and any other contention that arises from the evidence. The law requires that the presiding judge is to be impartial. You should not infer from anything I have done or said that evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find the facts and to render a verdict reflecting the truth. All 12 of you must agree to your verdict. You cannot reach a verdict by majority vote. When you have agreed upon unanimous verdicts as to each charge, your foreperson should so indicate on the verdict forms. After reaching the jury room, your first order of business is to select your foreperson. You may begin your deliberations when the bailiff delivers the verdict forms to you. Your foreperson should lead the deliberations. When you have unanimously agreed upon a verdict as to each charge and are ready to announce them, your foreperson should record your verdicts, date and sign the verdict forms, and notify the bailiff by knocking on the door or however else you've been letting them know that you're ready. And you'll be returned to the courtroom and your verdict will be announced. Thank you. So, first thing you're going to do is you're going to go back and you're going to pick who your foreperson is. You're going to let the bailiff know that you have done that, and we're going to send back this very official envelope. Inside this envelope will be 2 verdict forms, copy of the instructions I just gave you, and a notepad to write down if you have any questions or concerns. All right? I have my 3 alternates. You must stay with us because your Tom Brady moment may still arise. And so what we're going to do is first I'm going to have you just stay here in the courtroom for a moment while we excuse the first 12. And then we're going to take the 3 of you, and you're going to have a place you're going to be able to go to hang out. You are kind of in a different situation in that you still are kind of in your jury bubble. So don't talk amongst yourselves about the case yet. If for some reason you are called in to take a place of one of our 12 jurors here, I'll give you some additional instructions to everybody about how to proceed at that point, but that's nothing hopefully we're going to have to worry about at all. All right? So you get to take your notebooks with you, so you don't have to leave them in your chair. So I'm going to ask everybody else to please remain seated. First, let's take our first 12 jurors, and then if we'll take our 3 alternates. So my first 12, if you please follow the bailiff out. Let us know when you have picked your foreperson. And do we have somewhere we can put our 3 alternates? All right, we'll let our 3 alternates head out to your alternate place. You can take them with you. All right, all of our jurors are outside the courtroom at this time. Are there any requests for corrections or changes to the jury instructions from the state?
No, Your Honor.
On the defense?
No, thank you, Judge.
All right, we will print off the final copy for the jury and put that in with the verdict form and notepad. I plan on allowing the jury to continue to deliberate until 5. And unless they give some indication that they are right at making a decision, I'm going to let them go home at 5 and have them come back tomorrow morning. Is there anything else that either one of you want to address at this time?
Not for the state.
In the event that the jury asks to see a piece of evidence, I didn't know what the court's opinion is on that. Go ahead, Judge.
Yeah, let's wait to see what they want, and then we'll put on the record how everybody feels about that. If they want to watch video, typically we have them come back in. If they want biological evidence, we can have a conversation about whether that goes back with them or whether we bring them into the courtroom. And then we can deal with photos, and those are usually pretty easy to send back if everybody agrees.
Yes, Judge.
All right. They picked. All right. The jury has picked a foreperson, so I am going to send the verdict form, copy of the instructions, a notepad, and an official state pen to go back to our jurors and allow them to begin their deliberations. Thank you, sir. All right. We're going to be at ease, but there are a couple rules. First is I need the attorneys to always let Madam Clerk know where you're going to be at in case the jurors come back with a question. So do not wander far. All right. Number 2, although we're going to be at ease, I'm just going to ask everybody in the courtroom if you have, so let's keep the noise down since we're still technically in session. So if you have to have a long conversation, I just ask that you step outside into the hall to have that conversation. Anything else?
No, Your Honor.
No, thank you, Judge.
All right, we'll be at ease until such time as we need to address them. come on up. Thank you. All right. We have, do I have everybody here? I have everybody here. All right. We have a note from the jurors. Actually, it's a number of questions, so let me read them to everybody, and then we will go through. I will mark this as Court's Exhibit number 1. All right. Requests of the jury. 1, it's not numbered number 1, it just has a little dot. We would like a whiteboard or pad of paper on a stand. Second one written down is crime scene photos. Third line is Christian Sykes testimony on video. Fourth is video of petrol station. And fifth is cell phone data. Then question, do we have hard stop at 5? And last question, what time do we start tomorrow? All right. So, do we have somewhere in the courthouse a whiteboard?
The whiteboard that I use is in the back room. It was never touched, and it belongs to the courtroom itself.
I know I'm old, so I will say old things. Back when I was a DA, aside from walking uphill in the snow both ways, we used to have like the flip chart pads. Do you guys have that?
There used to be one in the closet back there. I don't know if it's still there. I think it may have gotten used up, and I'm not sure we've resupplied. We may have one in our office, but we're finding out.
Thank you. Because we may send both back to them. If not today, maybe tomorrow. So let me know when your folks have checked on that, and I appreciate entertaining that.
Yes, Your Honor.
All right. We'll need to erase the whiteboard before it goes back.
Oh, that right before I was referring to never got written on. It was the one I set up there but never actually wrote on.
Oh, okay.
Yes,
All
ma'am.
right. Is that yours?
No, ma'am. It was already here.
Okay. All right.
We do have a large flip chart thing.
Yes. I have no idea what the official name of that is. All right. All right. So, does anybody have any objection to sending back the whiteboard and the flip pad with them?
No objection from the defense.
No objection, Your Honor.
All right. Second thing, any objection to sending, and they only asked for the crime scene photos. Is there any objection to sending those back with the jurors?
No objection from the state.
The alternative is, if there is, we'll bring them in and let them go through them here in the courtroom.
I think for expediency's sake, maybe letting it go back there is okay. I've had an issue with it in the past, and so I think they may move a little faster if they do it here, whereas if it goes back there, that sometimes prolongs things. So that obviously it's up to the court's discretion, but
Actually, it's up to you. If you don't object, then it's up to me.
well, this time I will object, so you can make the decision.
Well, no, if you object, then the only alternative is they have to see them in the courtroom.
Yes, I would prefer that. I believe that would be the most effective way of doing it.
The third, Christian Sykes testimony on video, the only way I think that we can handle that is have them come in and replay that
Yes, Your Honor.
for them. The same for the video of the petrol station. The cell phone data, is there any objection to sending the cell phone data? I will clarify if they want the raw data or whether they're asking for the FBI analysis and or. But is there any objection to sending that back with them?
No, Judge.
I assume they want the cast report PDF. The raw data is on a disk, and so unless they have a means of looking at it, it also doesn't mean much without interpretation.
We'll see what they want, and then we can decide. All right. Do we have to stop at 5? Yes. Unless they are like, we're 15, 20 minutes from reaching a decision, we're going to let them go home tonight. And what time do we start tomorrow? Unless there's a request, we usually just start at 9:30. That gives district court a time to sort of clear out a little bit before we have everybody coming back to our courtroom.
We have no district court tomorrow, and I don't know if they're concerned about the potential weather coming in over the weekend and wanting to make sure they have sufficient.
We can start
time.
at 9.
I would be fine with that, Your Honor.
9 is fine, but when I looked at the weather, I don't think we're getting anything until later after we leave, so.
So before we bring the jury in, let's just talk really briefly about this. So I do not want the possibility of either two flakes or the storm of the century, who knows, occurring. So the general plan is we will excuse them at 5. I anticipate if the storm is anything like what is predicted, we will not be here Monday. We're going to arrange with the clerk's office to get their emails and then individually email them if they need to be present on Monday or on Tuesday.
Yes, ma'am.
That way, they will not have to be dependent on trying to catch it on the news or whatever, since we're trying to keep them away from the news, not because that isn't awesome, but just because we don't want any problems with that. We will figure out between us here in the courtroom, between the bailiffs, you all, me, how we'll keep each other informed.
Yes, ma'am. But as for the question of start time, if there's no issue with district court, we can all be here at 9 o'clock to get things going.
Yes, I will love it.
Especially if we have to sit and watch a bunch of video.
I think there's actually 3 courtrooms running tomorrow.
Oh.
What?
I got child support, civil, and small claims.
So that won't even be as big as one regular district court docket, though.
That's true.
Do we have enough personnel with the bailiffs to be able to cover?
Yeah.
Okay. All right. All right. Without any, all right. Seems like everybody is okay with being here at 9, so let's go ahead and get them in and let them start early.
Yes, Your Honor.
All right, so here are my answers to the jury's requests. We'll get them a whiteboard and a pad of paper with the stand so that they can take that back and use whatever they want to. 2, we're going to allow them to see the crime scene photos here in court tomorrow. We'll let them listen to Mr. Sykes' testimony on video tomorrow. We'll let them watch the video of the petrol station. I'm going to clarify what they mean by cell phone data. I am also assuming they want the FBI CAS report. If that's true, we'll send back the printed copies that were entered into evidence. And Madam DA, if you find out what number that is, or Madam Clerk, somebody get me an actual number.
I'm pretty sure it's 144.
And we don't have to do this right now.
It's 144.
Excellent. Find me the crime scene photo number so we can agree.
2 through 32.
That's correct.
Well, if you're going to be like that. All right. Sounds good. Anything else that you want to address or put on the record before we bring our jury back? I plan on answering the questions and then sending them home.
Nothing for me, Your Honor. Thank you.
Nothing from the defense. Thank you, Judge.
All right. Keep our alternates until after I answer the questions, and then I'll have them come in and we'll excuse them. Please. I think I know, but who is the foreperson on this jury? Stand up. Mr. Marini? Marini. Mr. Marini. I am not shocked. So, Ms. Marini, I received a note that I think you sent to me with a number of questions. So I want to answer them. We feel like we're at a position where we will reach a decision. I would agree to allow you to stay past 5. I am impressed that you all are so hardworking. You're already asking that question. But as you can see, I have a lot of court personnel that help assist in making sure this can all happen and happen safely. And I need to also take into account their families. So, and if it's, I usually don't go past 5 for y'all, but also just for everybody else. So if it's something that you need in order to reach the goal line, we can adjust. But if it's just because you're so hardworking and amazing, I'm just going to have you come back the next day. All right? In light of that, though, unless you all wanted to start later than usual, I was going to see if we couldn't start a little earlier. Would that be about what y'all want to do? That's it. So what we'll do, we'll get to that whiteboard and paper for tomorrow. I'll have them put it back in the jury room for you. We'll bring you in first thing in the morning, pass around the crime scene photos. We'll then play Mr. Sykes' video, and then we'll play the video from the petrol station. And then we'll send the cell phone data, which is states 144, back with you. You now kind of have an idea about stopping time and when we're going to start tomorrow. You all are fabulous. I want you to know this is a lot. We will take however much time we need to. You need to take however much time you need to. There's no clock ticking. I know you all have lives and jobs and things you want to get back to, but this is incredibly important, and you all have shown that you know that. So we will do, there's no rush. We'll be here. We'll make sure you all are okay until we get to that point where you all have reached a decision. All right? So I appreciate an amazing, hardworking attitude. I am going to let you all go home tonight because I don't think the answer is we're close to reaching a decision since you asked to look at some other evidence. What I'm going to ask you to do, if y'all don't mind, just sit here for a minute so I can, and you can go ahead and have a seat, I'm sorry. We're going to bring the alternates back so I can give you all of those amazing instructions again before I excuse everybody. So if we could bring our alternate folks back in, please.
Your Honor.
Yes. Oh, yeah, that'd be a good idea. Ms. Marini, we'll collect the verdict packet. And I'll have y'all leave your notepads in your chairs tonight because you're going to come back in here in the morning. So. I'm not sure where they are, so we'll just hang tight till they get here. Apparently, we keep them way far away from you all. I think they're still in the building, though, so we should be all right. All right, we have reacquired our alternates from whatever secret place we're keeping you. So just to my 3 alternates, thank you for being here. So your hardworking other 12 are so dedicated, they would like to start at 9 tomorrow morning. And since we don't have any district court, we can do that. Are you 3 okay with coming back at 9? Excellent. All right, so we are going to recess for the day. So I have to tell you all the rules again that you already know, but I have to make sure you haven't forgotten them in the interim. 1, remember, totally hang out tonight. Normally this would be Thursday night football, but there is none, so I don't know why you would get together. But if you do, remember you can talk about anything you want, just not talk about this case with each other. That can only happen with my 12 folks when you're back in the jury room with your super fancy verdict envelope, all right? Number 2, so go home. Remember, you can't talk to anybody else about this. You can only tell them you're in jury deliberations in this murder trial. Don't talk to anybody online. Don't talk to any of your neighbors. 3, remember, stay away from any publicity about this. Don't let anybody talk to you or around you about that. Just excuse yourself or tell them to go to the garage or whatever you need to do. In addition, no independent research. No AI, no Google, no whatever amazing things are out there, including those encyclopedias. I know you're dying to find some. All right. In addition to that, please remember, well, you don't have to keep your minds open anymore, but you can't talk about it. So don't talk about how your minds are until you all get together tomorrow and you start going over everything. All right. We're going to start back here in the jury room. And I probably have the 3 alternates. We're going to do a couple things and probably have you go to your, I don't even know where y'all are. Apparently it's 7 miles from here. But we'll send you to whatever secret place we have you as soon as everybody gets here in the morning. So if everybody, you can be back in the jury room, and you can go with them in the jury room until we bring you in and then separate out, okay? Because we still love them, right? Even though they're the alternates, okay? All right. With that, I'm going to have everybody leave your notepads and your notepads in your chairs. We'll get them and get them back to you tomorrow morning. Everybody else, please remain seated. At this time, we'll excuse our jury to 9 a.m. tomorrow morning. All right, all of our folks are outside of the courtroom. Anything we need to address on behalf of the state?
No, Your Honor.
On behalf of the defense?
No, Judge, thank you very much for asking.
Mr. Trapp, you doing all right?
Yeah, just.
I know.
My wife sent me a message saying the test went well, so just checking on that.
Well, and, you know, she's got to have something to keep her mind up. We're certainly trying to take care of that for her. All right, we'll see everybody back here tomorrow morning. We will start at 9 a.m. I would ask that the attorneys come back. I just want to talk briefly about the storm of the century and some of my thoughts on how we're going to handle that. All right? All right, everybody else, have a good, safe evening. We'll be back here at 9 a.m. tomorrow morning.